Lord, may I be permitted to mention, Lord, a suit that my argument was going on for defendant number 11. Your Lordship has been pleased to fix on 27th of July 2023. Lord, on that day, my Lord, and before 2 days, up to 27 July 2023, my Lord, I shall be out of station. That is why I have given notice to all the, including the plaintiff.
I will adjourn on that date.
They have agreed, my Lord, that
I will adjourn on that date. Let them come on that date.
yes,
I will fix the date.
Lordship, my learned friend will be mentioned. Lord, I am
Pasari,
Yes.
you are for defendant number?
defendant number 11, my Lord.
What is the listed matters to be mentioned? Item number 1.
Or I'm for the defendant number 3, madam.
So I am for the plaintiffs. Your Lordship will recall this matter is listed at my instance today, where this matter was fixed on 21st of July, and Mr. Joyjit
Changing.
Yes, your
Bothra matter.
Mm.
Sir,
change.
I am for the state, defendant number 1 and 2. My arguments are to comments because everybody else has
You
finished.
come on 21st?
I do not mind, my lord. If my learned friend is incapacitated or indisposed, my lord, we can adjourn.
To the order sheet. You are defendant number?
Your Lordship, I am the plaintiff.
You are plaintiff.
But I'm for the defendant 3, madam.
The learned counsel for the plaintiff submitted that the argument of the suit may be shifted from 21st July 2023 to some other subsequent dates. Let this time be fixed on 27th July. Okay?
Grateful to it.
Item number 2.
Lord, I'm for the plaintiff in this matter, my lord. I have mentioned this matter yesterday that the suit has been disposed, but the document, probably Exhibit A, the CS certificate of the suit property, is still in the records, my lord. So I'm praying for return of this record in.
The learned counsel for the
Plaintiff. I'm for the
plaintiff
plaintiff.
submitted that original document may be returned to the plaintiff. Leave is granted to take back the originals on undertaking to return the same as and when required. The plaintiff, the learned counsel shall also furnish authenticated copies of these documents for keeping on record.
Grateful, my lord.
In terms of original site rules.
Grateful, my lord.
New motions. Item number 3. Shivani Das.
None appears. Adjourn to 2nd August. Adjourn.
My lord, the receiver was supposed to hold a meeting. The receiver has already held a meeting. My lord, the receiver was supposed to place the report.
Like you.
Slightly. I saw the receiver outside. My lord, we kindly keep if you pass it over, my lord. Receiver has already prepared a minutes, my lord.
That property. That property.
100-year-old receiver. receiver
ABC are redundant.
ABC. That's yes, ABC has already been taken care of. The remaining prayers regarding that repairing part, my lord, that is remaining, my lord.
Only that part.
Yes, my lord, repairing part. That's a principal concern, my lord. Building is in a completely dilapidated, ruinous condition.
Repairing will not do. Repairing will not do possibly.
No, it depends upon the report of the receiver, what the receiver says, man. My lord, kindly pass it over, my lord, for some time, my lord. If I can get hold of the receiver, I will bring.
Pass over.
Pass.
Adjourn motion, item number 4, 5 and 6.
Your lordship, item number 4. কোডটা একটু ইয়ে নিচ্ছি, time নিচ্ছি। স্যার আসেনি। Actually,
4, 5.
Your lordship, item number 4.
4,
Mr.
5, 6, 3 matters.
Mr. Bimlendu Das is appearing for the applicant, your lordship.
Applicant.
I am appearing for the in item number 4, your lordship, for the applicant. I am praying for a adjournment, your lordship, in this matter.
Application to the 5 is about
Your application for addition of parties.
no, the 5 is for discharging, removing joint receivers.
There's one application for that, well, that is by the, well, that is GA 1819 old
5, GA 5 of
GA
19.
5, yes, well.
You are seeking adjournment in item number 4.
Item number 4, GA 5, your lordship.
GA 5. What about GA 6?
The GA 6 again, my lord, is this is old GA 390. Well, this is about,
Mitali Parui.
so this is again by one of the occupiers of the premises, my lord, shop rooms.
Who is for the petitioner here?
My lord, petitioner is Shushmita Das, the advocate is Mr. Nitin Kumar Das,
Where is he?
not here.
Then GA 10.
GA 10 is by the municipal corporation asking for
Some
arrears of,
directions were given.
yes, my lord. The directions were given upon the joint special officers, receivers to prepare, my lord, a schedule of the tenants who are occupying. My lord, there is only one problem that I'm facing. I appear for the receivers. My lord,
Yesterday, but day before yesterday, passed some order.
yes, my lord. That is in GA 9, my lord. This order,
Related to same issue.
yes, my lord, pertains to, my lord, who's in occupation. Only one issue here, my lord, in your lordship's order of 21st June, where we are facing some difficulty, my lord, with regards to the proportionate share of tax, which has to be borne by each occupier, my lord. The municipal corporation has not indicated ever as to what is the rate at which they are charging.
No issue. You submit that report, I will pass direction to
Yes,
KMC.
And my
for doing
lord,
that exercise.
they have perhaps also levied penalty. My lord, now the problem is,
Let them do their job.
yes, my lord.
You come with all these things.
All right, I'll do that.
Area of rent,
Yes,
how much is outstanding,
lordship.
from which point of time it's outstanding, all these things.
I'll do that. It is up to 1st June 23 that I have to prepare the.
What is the next date fixed in that matter?
My lord, that is coming up on, I think 7th of August, my lord. 7th of August, I think. My lord, this 10th August maybe. But the university is 10th August.
10th August.
Yes, my lord.
Adjourn to 10th August, all these matters.
Lordship.
Last order.
My lord, I appear on behalf of the defendant number 3. This-
Call hote de bhai.
Which matter?
Next para, my lord, I apologize.
I have not called yet. Item number 3.
Item 3. My lord, I was appointed as a receiver in this matter, my lord, by my lord.
Where is Mr. Dotto?
I believe Mr. Dotto's advocate on record is here, Mr. Prashad.
I am the advocate on record of.
He's here.
You are playing hide and seek.
No, my lord, I will indicate, my lord. My lord, by my lord's
Mr. Dotto
order,
has come.
my lord had directed.
I thought you are playing hide and seek, both of you.
Hey, no, not at all. Hey, at this age, my lord, no.
My lord, it's 10:30, several.
Hmm.
My lord, the thing is, my lord, I was appointed as a receiver by an order dated 28th of
Yes.
February. I was supposed to take charge and prepare a statement of accounts. My lord, this is a matter of 1998. A
Did you
partition
hold
suit.
meeting or not yet?
My lord, I held two meetings. My lord, in the first meeting pursuant to my lord's order of 28th February, it was indicated to me that there is one surviving receiver who would have the accounts and records in respect of the proceedings. My lord, there on inquiry, it had come to the knowledge that around April, May, that receiver was unwell and he had passed away. My lord,
Not in
his-
April, May, February.
no, my lord, my lord's order is in February. My lord, the receiver was contacted. He was very.
I informed Mr. Dotto. He
Yes.
required.
My lord. My lord,
My lord,
his,
yes,
his thereafter his son indicated that he was in the period of bereavement and the records could not be made over.
You meet with his son. He will go. He will do.
Very well, my lord. If my lord directs, I will do so. And my lord, yesterday also a meeting was held. Mr. Dotto indicated that I take physical inspection. I indicated that the order does not permit me to do so. My lord, I will first take this step of meeting the son and taking all the records, my lord.
Was it in the order?
No.
My
Physical
lord, no, my
inspection?
lord. No, my lord.
There has to be a specific order and one additional, my lord, will, prayer, my lord, I have, my lord, that the receiver will once, my lord, take a physical inspection, make an inventory of the property, my lord.
The
So
landed receiver is present today and submitted that several meetings were held. Full stop. However, the landed receiver please leave to inspect the premises so as to ascertain the present state of condition. The landed receiver, full stop, no, the landed receiver in course of discharging of his duty shall inspect the premises, shall take accounts of repairing works and do all the incidental and needful acts necessary. The landed receiver is expected to submit a report before the returnable date. Let the matter appear in the list on 25th August.
Great. Grateful.
For framing of issues, item number 7.
My lord, item number
My lord,
7.
I appear for the plaintiff in number 7. My lord.
Suggested issues?
Yes, my lord.
Please.
My lord, here, my lord, this is suit for partition. My lord,
What this application is about?
My lord, one application,
32?
IHS 32 is my application by the executor of the will of the deceased defendant number 1. For being appointed to represent the estate of the deceased defendant. On the last occasion when I have moved this application, it was indicated by my learned friends that the copy of the will has not been disclosed. So we have given a copy, but the will was not before the court. I have prepared a supplementary affidavit, my lord, to bring on record that will. This is, my lord, the supplementary affidavit.
my lord, we have been served with a copy of this will and the application, my lord. We'll file an opposition to this, my lord. Short affidavit.
Have you got it?
Yes.
I
So intend to file an opposition to this application, my lord.
Landed counsel appearing for
For
the you are for plaintiff.
I am for the plaintiff, my
I
lord.
do appear for defendant number 3.
Number 3.
My lord,
Fine.
I appear for numbers 2A, 2B, and 4, my lord. I'm
Why
so
you are-
sorry, my lord. I'm appearing on the virtual mode, my lord.
Why?
My lord, perhaps infected with conjunctivitis, my lord. So
Okay.
didn't take the chance to infect my learned friends as well.
Okay.
Lordship, I'm appearing for defendant number 6. He had filed an affidavit of documents, but after the inspection was given, certain irregularities.
Just a minute. Let me pass this part of order.
Lordship.
Supplementary affidavit is filed by the landed counsel for the defendant number 3. Full stop. Reply if opposition, if any, comma, as prayed for, as prayed by the learned counsel for the plaintiff shall be filed within 2 weeks.
My lord, even I want to file an opposition to that application.
Therefore,
I appear for the numbers 2A, 2B, and 4.
defendant,
Defendant, my lord.
the learned counsel for the defendant number 2A, 2B,
And 4, my lord.
and 4 also craves leave to file opposition. Full stop. The parties shall exchange affidavits before the returnable date. Affidavit in reply. All the affidavit in opposition shall be filed within 2 weeks. And affidavit in reply is to be filed within 1 week thereafter. Yes, what you have said?
I'm praying your lordship slightly to allow me to file an amended affidavit of documents. Certain irregularities had.
You are for?
I'm for defendant number 6.
The learned counsel for the defendant.
Well,
number 6.
inspection has been taken, well, everything is done, well, now everything is over, my lord. We have filed affidavit of documents also. Affidavit of admission denial is also complete.
Yes, your lordship. After the inspection was given, certain irregularities. Irregularities in the with the pleadings and the documents annexed. Certain irregularities were cited. That's why I'm praying before your lordship. Let me file an amended affidavit of documents.
The learned counsel for the defendant number 7.
6, your lordship.
6. Craves leave to file amended
Affidavit of documents.
affidavit of documents. Leave is granted.
My lord, in the event,
Yes, yes.
that in the event, my lord, an amended affidavit of documents is filed by the defendant number 6, my lord, that may also be circulated because we have not come across, my lord, what are the documents.
Let that be filed
Very
first.
No, my lord, we need to file our affidavit of admission and denial, my lord. It's done
Affidavit of admission and denial document
by the
filed
plaintiff.
by the plaintiff as well as
Defendant number 3.
defendant number 3 be kept in record.
Now, my lord, the other part of last order, my lord, what was framing of issues. My lord, I have come prepared with, my lord, a list of suggested issues.
Let these things be done. These things be done, then issues will be framed. The matter will appear in the list on 21st August.
Great.
Very well.
But in the meantime, I would also like to file my statement of admission and denial, but because I was that I could not. Statement of admission denial exchanged by the documents.
May be filed by the defendant number
2A, 2B, and 4, my lord.
2B, 2B, and 4.
Great. Deeply obliged, my lord.
Since this exercise is yet to be done, thereafter issues should be
Very well, my lord.
ideally.
Very well.
For hearing item number 8.
My lord, I am for the plaintiff. My lord.
But I was addressing your lordship on the question of judgment upon admission.
Your point was it is their admission.
My lord, their admission by mistake, my lord, it was written.
Plaintiff's witness came and said it was taken.
Plaintiff's witness came and said, my lord, that too for the period 2007, 7 and 8. Ours is, my lord, ours is for 1990, 1991 to 94. Mr. Dhruva Ghosh said, if you take that to be the benchmark in 2007, 2008, 10 to 15, then by that calculation,
Supreme Court observe it was 31 rupees 31 per square feet.
no, their witness said that it was 10 to 15.
This is in the judgment of
That is the judgment. Judgment we will come later on. Huh? Judgment is a lot of things. My lord, what?
31 rupees we had prayed.
Yes.
That is the prayer in the plaint. That is prayer in the plaint, and the special officer granted what 60 per square. That is different. That is I will attack every. Now, my lord, what was done?
It is confined within 10.
Yes. I will confine a 3-page note. I will give you for where the points are. I told you that. my lord, just what happened, my lord, this is a huge building. Many floors are there. So I am not the landlord of the premises. The best person to know about the landlord of the premises is the plaintiff. So, my lord, we said you produce the other, my lord, the rent agreement of the other, so we know what is the value. So, my lord, what came in evidence, একটু বসো আমি বলছি তো,
না, না, আমি কিছু বলিনি।
very
But I'm intimidating.
intimidating.
I'm so sorry.
Now, Millard, so Millard, I will tell you the crux of the matter. So, Millard, we produced two agreements. One of Millard, we came to know about this injunction and another company, I forgot, Reliance. Now, Millard, we showed the rent agreement. We said in 2000, 2007, 2008, it is 10 rupees or 15 rupees maximum. 10 rupees, 15 rupees maximum. So those agreements were on record. Then the witness of the plaintiff came and said, and we cross-examined. He said, yes, it is in 2007, 2008 to rupees 10 to 15, and said if it's 2007 to 2008, then 3 years back calculation at 10%. How much is it? 91. And our admission, our so-called admission is not 5 rupees. It comes down to 5 rupees per square feet. This is recorded in the special officer's report, which I want to say. And the special officer's report records that the witness of the plaintiff came and said it is rupees 10 or 15 in 2000, 2007, 2008. By mistake, when the first affidavit came, Millard, in the sorry, not the second affidavit came as reply to this judgment of an admission. It says we said that the defendant has admitted. It should be the plaintiff has admitted. We corrected that. There was an opportunity given by you again to file supplementary. To that supplementary, we are entitled to file. We corrected that. This is the short point.
You note.
Not. I will quickly, may I place one after the other, and this is the short point.
If you're placing the.
Obviously. And I'm going. Malad, I prepared the note. I have a after me, they'll continue if you permit me. Malad, just quickly, I'm telling you. So, Malad, last time I showed you their application for judgment upon admission. That is GA 11, I presume. There, Millard, I showed you, Millard, what they say in paragraph 16 of GA 11, what the so-called admission is, and they say, and they say that although it is 10 to 15, and their averment in paragraph 16 is may be deemed to be an admission, and they say liable to pay 15 rupees, although it is mentioned 10 to 15. That Millard, and they say they calculate on the basis of rupees 15, and they also claim 9% interest, and they say that before pending disposal of GA 9 of 2019, the defendant should be directed to pay. What is GA 9? Millard, GA 9 is their application to affirm this report. So to that is the first application. Now, Millard, then we this is Millard paragraph 17 of GA 11. You will say they say you must pay at least rupees 11 lakhs. And their prayer in the application I showed your lordship is that make payment of rupees 15 per square feet, whatever. Why 15? I do not know, because if you take it to be an admission, it is rupees 10, and that is what you directed. Now, there is another one thing I must point out. In the subsequent affidavit appears, during this interim period, I paid about 1 crore 8. 1 crore 8. Now, assuming the highest possible admission, if you think it is to be an admission, which I say it is not. My admission on the basis of report is rupees 5 per square feet, if at all, my lord. If you think rupees 10 per square feet, you have directed a sum. The first day I came, I said, if you find, we are statutory, we are not running away. So I'm willing to deposit, and I deposited. And I complied with the order. That's the first day I appeared. I said we should. And when a statutory body has said this, put in that money. That's what your lordship did. Now, my lord, subsequently it transpires that I have already in the written statement paid 1 crore 8 for this period. So, my lord, which has been admitted, my lord, in the subsequent affidavit by them. So deduction has to be given. They say 72 lakhs. Say, why? Because they say the rest is on account of taxes or whatever it is. So whatever it is, 1 crore 8 has to be deducted. So, my lord, if you are thinking about making payment to on the basis of my so-called admission of rupees 10, it should be 2 crore, whatever I deposited, minus 1 crore 8. Minus 1 crore 8. So this is the first thing, one thing you have to take note of. And then, my lord, there is no admission. I will show you immediately why there is no admission. My lord, will your lordship kindly see my first affidavit, which came on record prior to the filing of this affidavit or in opposition to GA 11. My lord, is the affidavit affirmed on 25th April 2019 in GA 10 of 2019. What is GA 10? Oh, huh?
May I have your lordship's leave for a few minutes?
চলে আমি বেশি কোনো আমার একটা ফিক্সড আছে না you continue. No, finish it. No, please finish it. Then ask Dhruva to come. Yes, my lord, will you just give me what is GA9?
GA9 is for
Application go down.
Report and GA10.
Exception to the report.
Okay. Thank you. Yes. Now, my lord, so we filed an application for taking exception to the report. My lord, that application, that is GA 10 of 2019. My lord, just have a look. This is prior to my affidavit. This is, my lord, just look at paragraph 14.
Of GA10.
Of GA10, that is my application. My lord, my application came before the affidavit in opposition. My lord, it is affirmed on 25th April 2000. Paragraph 14. What have I said, my lord?
One witness of the plaintiff.
Yes. This is my witness of the plaintiff. Now, assessed rent at rupees 10 per square feet. That is what I have said. Now, my lord, we kindly see, without considering market rate during relevant period. I have said, relevant, what is the relevant period, my lord? Relevant period is 91 to 94. 10 rupees is what period? 27 to 2007, 2008. So, Mr. Dhruva, you will find it all recorded in the special officer report. Back calculation 3 years, then how much does it come to? It comes to about rupees 5. So, my lord, it's not that I'm taking this point for the first time in the opposition. Opposition, I have denied it. So, my lord, prior to the opposition in GA judgment upon admission, I have said, my lord, rupees plaintiff, witness of the plaintiff, I have corrected. My lord has said this. Now, my lord, kindly take page 8, ground VIII. My lord, please, this one. Because this is my first opposition.
GA10.
No, yes, GA10. That is the application, GA10. GA10 is application. My lord has it. My lord has it. This is, my lord, page 8, ground VIII. Why are you asking for setting aside?
Panmal Setia.
Yes, his witness.
Rate of rent 2007-8.
7-8. Rupees 10. Kindly see, my lord, ground IX, page 9.
Yes, that you have mentioned. 9. Making rupees 10
Right.
square feet as a base calculation.
Right. I said in 2007-8 by Panmal Setia. I have not said this. By mistake, my lord, what happened? By mistake, when I filed the first affidavit in 2009, affidavit.
What is your exception?
This is the exception.
This is exception.
Yes. When I filed first the exception, then I filed my opposition to GA 11. Kindly take my opposition now. In this context, you have seen my first affidavit in the form of an exception. My lord, now the proper affidavit in terms of the exception. May I kindly see affidavit in opposition GA 11 of 2019, affirmed on 30th July 2019. May I paragraph 3 small e, page 3. Paragraph 3 small e, page 3. What have I said? If your lordship just marks,
Paragraph, page.
page 3. I've written it in the note. What's the use? Yes.
Can I misconstrue this statement?
Misconstrued the statement. Cannot be read in isolation. It is not an admission. I said this. Has your lordship? See, then kindly see para 5, page 5. Page 5. Not entitled to any means of it. Has your lordship found it? Para 5, page 5 of that application, of that affidavit. Has your lordship found that? Not entitled. Then para 7, page 6.
Inferential admission.
Yes, para 7, page 7. Rental agreement would not be more than rupees 23 lakhs odd for that period of 31 months. Has your lordship found that? The entire 31 months, I say, may not para 7, page 6. Has your lordship found that? Which one is your lordship looking? Affidavit in opposition to GA? Yes. Para 7, page 6. Has your lordship found that? Para 7, page 6. Is your lordship looking at my affidavit in opposition?
411 to 31/5 would not be more than 2378.
Correct. Which period? 411, 91 to 94. These are the months. So I said, oh, it can't be more than 23. Of course, rental. Then I say, not kindly see the total area. Total area is 57,105 square feet, 2 floors, rather 3 floors. Basically 20. That. Then kindly see, I say how much it will be the per square feet. My lord, if you divide 2378 divided by 57, you will come to 1.343 square feet. Rupees 1.3.4. My lord, it's not written there. It's mathematics. If you divide 23 lakh 78 by 57,000, it will come to, I've calculated, you can note it, rupees 1,343 per square feet. And then I have said, it's in the general law in order 12, it is not clear, it is unambiguous. I have said that. You can see that, my lord. Now, my lord, comes the supplementary affidavit in GA 11. Filed by the plaintiff.
Supplementary affidavit.
Yes, please have a, this is affirmed on 18th May 2023. Just have a look at para 3, page 2.
Yes.
May I read it? In your note, I've quoted it, so that your lordship does not even have to look at the. Kindly see, the petitioner states that in the application, has your lordship found? Yes, the petitioner has claimed a judgment upon it, upon the respondent's admission that the defendant, with all documentary evidence and with established procedure method calculating rent, prove that the ground rent occupation charges can at the best be 10 to rupees 15. Actually, it is by the plaintiff. That is kindly per square feet per month. Accordingly, in the instant application, the petitioner has calculated mean profit at the rate of rupees 15. Why 15 firstly? Why? May not kindly see per month for the period wrongful. The period for illegal occupation, then my lord kindly see, is 1990 to 94 for the second, third, and from 91 to 94 for fourth period. Fourth floor. And say this is and per. Now may not clearly saying that for 1994. So, my lord, rupees 10 part and 15 is for 2007, 2008. My lord, what is? You determine from the basis of the report. But what will be the, this is at the highest, so assuming everything against me, I have admitted rupees 10 of 2007, 2008. Did I make any admission for that period, 90 to 94? One aspect. Then kindly, my opposition may not to this supplementary affidavit is very important. Para 6, page 3, with supplementary affidavit affirmed on 9 June 2023. To GA, to the judgment upon supplementary. I have given a reply to this. Kindly have a look at para 6, page 3. They have reiterated whatever they wanted to say again in that affidavit to the GA. Now kindly see my supplementary affidavit affirmed on 9 June 2023.
Which page?
Para 6, page 3.
Yes.
I request your lordship to read that today, Tomake. Affidavit ta dena. My lord, I have said it is admission of the plaintiff's witness. My lord, your lordship can see. My lord, my lord, yes. Page 6, page 3. I say the submission quoted in paragraph reference.
Last two lines.
Yes.
And first couple of lines of page 4.
Page 4. Yes.
Look at the first line of page 4.
Yes. And Minad, I said somewhere.
There is no admission in the middle of the.
Yes.
In any,
Yes, yes, in the middle. The purported admission of plaintiffs to petitioners.
that you have mentioned.
Yes, I mentioned clearly. Now, Minad, what they are picking, Minad, by mistake, in the original affidavit, when they filed to the site, there was an averment that the defendant witness has that now see defendant witness. Now see, Minad, the special officer's report. Special officer has reported who has admitted.
So in view of that, it is the plaintiff's admission.
Yes. See the report now. See the report now.
And according to you, even if rupees 10 is allowed, then he.
Manat, even 10 rupees 1 crore 8 has to be deducted.
Yes.
Yes.
1 crore is to 1.
Manat, I will show that. That portion I will show a little later, that where they have admitted 1 crore 8 has to be deducted. 1. Then, Milord, the rupees 10 per square feet is for 2007, 2008.
So according to you, there should be a back calculation for which it will come down.
That is recorded in the special officer's report.
That is the nutshell of your argument.
That is the nutshell, Milord. There is no admission. Clear, what are with those 3 words? I forget. Clear, unambiguous, and what? Unequivocal. All this and matters going on. I mean, not on this square, the Supreme Court, this, that. I mean, not you have to only look at. It's up to you whether there is an admission or not. I'm not saying not liable, but question is admission, judgment of an admission or not. Right? So, just quickly, just special officer's report. Where is the special? Which one will I show? Yes, GA9 থেকে করেছো কেন judgment of my addition is special officer's report name? You're right. The special officer's report is annexed to the GA11 judgment of an admission. So, Milord, which page is it? This, Milord, I think it begins page 91. My lord, page 91.
I marked it.
You have marked it, my lord. My lord, kindly see one by one. My lord, page 91, para 25 is my witness, DW2 Gita Moitro. My lord, has your lordship found?
Giti Moitro.
Gita, I said Giti. Giti Moitro relied upon, my lord, what? Tenancy agreements of which period, my lord? 2007, 15, And my lord, lease deed of Reliance, 2008 for 10. My lord, has your lordship found that? Yes. Then my lord, kindly come straight away to my lord, paragraph 33. My lord, kindly see paragraph 33. My lord, argument of Dhruvo kotha hai, bhai? Senior counsel opposes no specific quantum pleaded in the then lease agreement.
He submits that plaintiff's witness.
Yes, because I cross-examined. My lord, he again came to give evidence. My lord, after Giti Maitro, this Panmal Setia. He submits that the plaintiff's witness has already admitted rent prevailing in 2007-8. May not we cross-examined because he was recalled, Panmal Setia. After Giti Maitro gave this evidence, then may not what Mr. Dhruvo Ghosh, because he had no agreement in front of him. He could only procure Millard of agreement of 2007-8, which was in their possession. So on that basis, he says, look here, if you do back calculation, it comes to 5 rupees. Millard. So to counter all that, the plaintiff's witness again was recalled, this Panwal Setia. Panwal Setia said, yes, I admit it is 2007 and 2008. So in that context, he is saying, Millard, he submits that the plaintiff's witness has already admitted rate of rent in 2007-8 was 10 per, and based on back calculation method and capitalization method, by making a broad assumption that annual rent is normally 10%. In 94, it should not be more than 5.9. This is the admission. When has your lordship found it?
I found it, but what is the basis on which the
10%.
special officer came to the conclusion it will be 61?
Manad, when it comes, I think I have some case to take exception to the report. Manad, your lordship will hear me. I won't take much time. I think this is time. Manad, it's absolutely perverse. Completely perverse. Please bear with me. I'm just finishing this small point of judgment upon admission. Your lordship will hear day-to-day basis of and finish this matter. Then may not kindly just দাঁড়াও আমি দেখছি বিনীতা ইয়েতে ডাকো আমার এক্ষুনি ধরবো may not kindly see 34. May not 34 last line, last 2 lines. Mr. Ghosh refers to question 44. May not 44. 2 PW1 Panwal Setia in his examination states that there is a clear admission on his part. Admission on his part. কোথায় গেল? কোথায় রে? আরে চলে গেল তোমার। Oh, is the best piece of evidence to show that rupees 10 was the market rate per square feet per month in 2007. In 2007. And that is what may not it's been construed so admission of the Panwal Setia, then may not kindly take 36. Kindly see, may not.
Plaintiff's own witness.
Yes, and later on, last line. Has your lordship found it? Yes. May not end of the special officer's report. Now may not rupees 1.08 has to be deducted from whatever amount you have. May not, in fact, I was not required, according to me, to pay anything on account. That's my further argument when I cite. I am not required. May I just indicate one point when I argue? It's not proper for me to argue at this stage, but I'm indicating to you. Millard, this is the time when Millard, they asked for enhancement of rent for this period. Asked for enhancement of rent. They quantified the damages and I paid the entire period. So my case is, you can't. You can't, there's no, you have not suffered damages for wrongful possession. If a person may not, what is mean profit? Damages for breach for continuation. So if during the continuation, you assess and you said, no, you have to pay this extra and I pay it, is there any mean profit? That's a separate argument, which I'll come to that when I argue mean profit. And even because the quantum, I think I have more or less some case which has to be judged by your lordship later on. No, madam, oh, this is just one thing, madam. Then why should 1.08 crores must be deducted? Kindly see, my lord, the affidavit in reply, which has been filed by them to GA 11 of 2019, para 4, page 5. My lord, it is affirmed on 24th April 2023. 24th April 2023. My lord, it is in GA. They said in the reply. And it is after all this that your lordship said, I am not understanding the calculation. Please file a supplementary. My lord, para 4, page 5. Now, my lord, they say that after adjusting payments already made, as your lordship found, and they say as per annexure B, page 37, has your lordship found?
After adjustment,
After adjustment, they agree that there is something to be adjusted, that I have already paid, something to be adjusted. My lord, has your lordship found that? Annexure B, page 37. এবার আমি তোমাকে ছেড়ে দিয়ে আমি চলে যাব। My lord, I have been guillotined. All the two juniors all run away.
Which annexure?
My lord, page annexure B, page 37.
Yes, item number?
My lord, you see 72 lakhs, 23,326, they themselves say has to be deducted for whatever calculation. Has your lordship found that?
Amount paid.
Yes, third column.
Second column, third column, yes. Amount paid to the landlord.
Right, they say 72 lakhs. They themselves on their own, they adjust. My lord, first the calculation is wrong, second column.
So payable is 2 crore 16.
No, that is on the basis of 15. That is on the basis.
That is their calculation.
That is their calculation. Yes, and they deduct 72. My lord, has your lordship found it? Yes. Now, my lord, why? My case is why 72? It should be 1 crore 8, because that's my case in the written statement. Now, my lord, for that, my lord, there is a supplementary affidavit affirmed, my lord, on 18th May 2023 by them.
Where is that?
Well, a supplementary affidavit affirmed by them on 18th May 2023, para 4, page 2. Manad, has your lordship
They
found?
mentioned 72.
Yes, para 4, page
1 lakh 8.
1 crore.
8. Sorry, 1 crore 8.
Admitted, but they on their own decide to adjust only 72. Has your lordship found it? So they know we have paid.
Now, admittedly, the petitioner has received from the respondent.
Right. And they make their own. This is on account of this. That is on account of this. So I won't adjust 1 crore 8. I will adjust 72 lakh. Well, this can be done in a judgment of.
What they have said, 72 lakhs are adjusted against one head, 36 lakhs adjusted towards contractual liabilities.
So
it is their point.
That is their point. In my judgment upon admission point. Well, they admit that 1 crore 8. This much is proved from their admission. Then may not kindly see, may not what I have said. What I have said is a reply to this. May not on 9th June 2023, my
reply, where is the reply?
yes, please, একটা reply দেখুন তো দিয়ে দিন। or rather opposition to this. Malad, these are all in GA 11.
Shown on 20th June.
No, my lord. It should be on 9th June. I have made. Taito. না কি ভুল বলেছো তোমরা? Have you got it, my lord? Yes. My lord, kindly come to para 7, page 5. In the middle.
Bifurcation is illegal.
Illegal. Then almost 2 crore 28.
Heads of adjustments are disputed by you.
My lord.
Heads of adjustment
Yes.
are disputed by you.
Yes. My lord, kindly see. Then I have said also about 2 crore 28 is lying with your lordship's officer. My lord, will you please please have a look at the entire paragraph? My defense to the section setting aside will also come out.
You have denied can claim a sum of rupees 2 crore 69 lakhs.
Yes. And also, my lord, please read the entirety. You will appreciate.
Yes.
And then, my lord, right at the end.
It is stated that special referee could not have awarded.
Right. Because, my lord, it was on the basis of a report of Mr. Ajoy Krishna Chatterjee in respect of a flat of Jute Corporation of India for a particular period. And the special officer, my lord, got mesmerized. Report of special officer, my lord, Ajoy Krishna Chatterjee says this. But Ajoy Krishna Chatterjee's report was set aside by the Supreme Court, which we didn't know at that point of time. Matter referred to Justice Suhas Sen, arbitrator, to determine quantum of mean profit. Agreement was executed to determine for the enhanced period, for the following period, rupees 3.33 basic rent. That is a separate issue. I don't want to, but whatever it is, I'm on, my lord, 1.08 crores. I'm only on that question. Also have a look at para 5, page 3. Para 5, page 3. Kichu devo na toke.
Inconsistent and contradictory statements.
Yes, my lord, কোথায় রাখলাম রে? এই প্যারা 5 পেজ 3 কি করে হলো? না না, সেটা তো আমি এখানে লিখেছি ভুল করে। প্যারা 5 পেজ 3 কি করে? না না না, no no. No no, 1 crore has to be deducted কোথায়? তুই এসে গেছিস? এই তো। আরেকটা কোথায় আছে? আরেকটা মানে just a minute, somewhere else also. Yes, my lord, kindly have a look at page 7. I have said, my lord, rupees 2.2 crores is lying deposited. Etc. etc.
Page 7 of?
Page 7, my lord, of this
Dated 9 June.
Yes. I said that 2 crore 28 is lying and this 1 crore 08 has to be deducted. Anyway.
That you have stated somewhere else.
Yes. Oh, I showed you just now that adjustment is illegal. Para 7, page 5. The bifurcation of 1/8 is illegal. Has your lordship found para 7, page 5? I just now showed your lordship.
This is in page.
Page 5, my lord. Para 7, page 5. Has your lordship found? Yes. Now, my lord, one submission. In short, there is no admission of the defendant. The reference to defendant in GA9 is obviously a mistake, which I have said so. Defendant should read as plaintiff. In my para 6, page 3 of my opposition, affirmed on 6 June 2023. This is the one, para 6, page 3. I have said so.
Yes.
Yes, I have said so. I have said so. I've given explanation to side. Now, my lord, then the final submission is that, assuming without admission anything, you say that my witness Gita Moitro said rupees 10 or which I showed you, paragraph 23. Then I submit, my lord, that it is for the period 2007-2008, my lord. And if you make a note of that we have said, Mr. Dubogos has said it is cannot be more than 5.9 per year. And my lord, the paragraph, my lord, this is note. Will you give leave to him to continue? I finished. Just note. No. No more.
My learned senior is finished. It's finished.
No more. Paragraph of the report. Gita Moitro, sir. But only from the report of the special referee, he will point out, and the note will be submitted. Yes. May I take your leave, Minute?
I should not have come in.
That was mentioned, in fact. Special referees. Anyway.
Yes. Well, what my learned senior was showing, my lord, is from the special officer's report, my lord, to show that what was the basis of this statement that was allegedly made in the affidavit in opposition. My lord comes to page 84 of the application. G11, page 84. Your lordship is hearing G11.
Yes.
Paragraph 11. This is our witness, DW2. Mrs. Gita Moitro relied on the following documents. And one 1992 deed, 94 deed, 2008 and 2007. 4 documents. If my lord comes to the 4th one, tenancy agreement of 2nd August 2007 executed by the plaintiff. So for an area of such and such. Then if my lord comes to paragraph page 91. So relying on these documents, we had relied on these documents. Then page 91, paragraph 25. DW2 Gita Moitro also produced and relied on photocopies of 2 rental agreements in respect of 2 separate portions. One was the tenancy of 2nd August between the plaintiff and 1 M Junction, showing rental at 15 rupees per month. The other being a deed of 2008 between the plaintiff and the Reliance, showing a rental of 10 rupees per month. They stated that in view of those documents, the rental values during 2007 and 8 are between 10 rupees and 15 rupees. Now, when this was summarized in my affidavit in opposition to a completely different application, in the affidavit, it was said that the plaintiffs have said at best it can be. But this is what the defendant had said. Our defendant had said it. So that is, if my lord comes to that admission, page 133, Now, before that, may I just complete the special officer's report, paragraph 33 also, before I come to show that why it's not an admission. 33 was the submissions that we made. And I have not said between 5 and 10 actually. So and so appearing for the defendant opposes the claim. He submits that no specific quantum of mean profits has been pleaded by the plaintiff before the special referee. The plaintiff has not produced the best evidence, that is the lease agreement subsisting during 91 and 94. This is the relevant period, 91, 94, not 2008, 2009. And in that same building, they have other tenants. They have not disclosed the tenancies of those in the subject premises, and by reason of non-production of relevant documents, adverse inference should be drawn. He submits that the PW1 has already admitted that the rent prevailing in 2007-2008 was rupees 10 per month based on back calculation method and capitalization methods by taking a broad assumption that the annual rent is normally 10% of the sale value. So very broadly it was said, and this is their witness has said, he has admitted that in 2007-8 it should be only 10 rupees. And deducting 10% every 3 years by back calculation. The fair rent, by deducting 10% every 3 years, the rate of fair rent during 91-94 should not be more than 5.9. So on a completely theoretical basis, this was the submission that was made in the before the special referee. But the special referee has given 60 rupees. Now, when they come for confirmation of that 60 rupees, in my affidavit, we have written in passing somewhere, it's not that they have said it is 60 rupees and I have said, no, it's 10 rupees. In passing, I have said at best, it is between 10 to 15. Now, that was the entire thing. Now, the document is before my lord. The evidence was 10 to 15 in 2007, 2008. So if back calculation is done, it would be much less than 10 rupees. That's our main. So taking a cue from that one statement in my affidavit opposition to their application for confirmation, we have not said that in our, when we take exception, we have said we proved it's about 3 rupees something. But this argument of mine is being misconstrued by saying that we have said, admitted that is between 10 to 15. 10 to 15 in 2008. Back calculation for 91, 94, it will be much less. And this is the figure we had given as a matter of theory, because there's not evidence of 5.9. Then he further submits that the plaintiff is not entitled to claim any more than the core rent between 91 and 94. Core rent was about 3 rupees something. So that was what we've been arguing. He states that the whole evidence of the plaintiff has only shown the market rate of rent, but they have not proved what the defendant received or might have received. That is, in respect of this particular premises, what was the rent? They have suppressed the best evidence because other tenants are there. This is an air-conditioned market, so there are full of tenants, and there would have been tenants in 91, 94 also. Then we would have known the market rate of rent. Then section 2 of the CPC is pleaded. Then, my lord, paragraph 43. I'll just end one. This argument which I had made, my lord, before the special referee, we will argue when the exception. Your lordship is hearing the so-called judgment on admission application. Now, list one more paragraph, page 101, page 40, paragraph 43. This is the same argument again. Well, paragraph 43 begins with the registered lease of 21st November 1988, and then the evidence is referred to. Now, if my lord comes to the just above the last paragraph, the defendant argued that the rent for the suit in the premises in 2007-8, as per agreement, will be worked out between rupees 5.9 per square foot, based on back calculation, reducing 10% every 3 years. It is therefore contended that the fair rate of rent in 91-94 should not be more than 5.9 per month, based on the above rate of rent of rupees 10 per month in respect of the premise. So if the rate in 2007-8 was rupees 10, my rent here by back calculation would have been 5 point. So this is the submission of mine, which is recorded by the special officer. Now, if my lord reads that paragraph 9, that page 133 of the, they have annexed to that petition. Yeah. Well, page 133. On the basis of these submissions and this evidence that was before the special referee. Now, in that light, my lord will read paragraph 9 at page 133. It is submitted that the defendant has adduced evidence in the special referee proceedings, wherein detailed calculation was submitted before the special referee with documents. However, the same has not been considered. The defendant, with all documentary evidence and with established procedure and method calculating the rent, proved that the ground rent or occupational charges of the subject premises can be at best rupees 10 to 15 per square foot per month. Well, this is where what Mr. Bose is pointing out is that it's the draftsman's fault. 10 to 15 per month in 2007, 2008. Now, since the records are there, I can say this. This statement was not there. So if it is at best 10 to 15 in 2007 and 8, then by back calculation, it cannot be more than 5.9. Then there were other points which have not been taken, whether the air conditioning was allowed, what was the maintenance, etc. So once those are reduced, well, it will come to around 3 rupees something, which was the rate of rent given to us in these. So on the basis of this now, they are seeking and literally a decree. They wanted security, your lordship allowed them. They said, yes, 10 rupees is a minimum amount you deposit. We have deposited. If they take that money by furnishing bank guarantee, etc., we don't mind. But the lordship will see the prayer in G11. It's not for judgment on admission. They are not seeking a decree. They are saying my decree, they want a decree in terms of 60 rupees per square foot in GA7. My lord sees the prayers. An order directing the defendant to pay rupees 11 crores, etc., at the rate of rupees 15 per square foot with interest at 9%. Admit a liability. If I say you have to pay mean profits, I say yes, I have to pay mean profits. That's my admission of my liability. Then they say that you have to pay at 60 rupees. I said
Quantification.
Quantification and estimation. It's the argument is going on. We have lost before the special referee. That matters GA9, which will have to be heard. But before GA9 is heard, they make this application. So by giving it a generous interpretation, this is an application for security. That my decree application is being heard, whether the decree will, there's no decree as far as the quantum is concerned. I am liable for mean profits, I admit that. Now the question is quantification. One exercise has been done. We are saying that it is contrary to the evidence. The evidence shows at best it was 10 rupees or 15 rupees, 2 deeds that we have relied on. That is shown there. And now that is being misconstrued in saying I have admitted. But the words as at best can be is an estimation. It's not.
So according to you, the yes should be put there. Yes.
Yes, because they are referring to that was my submission before the special referee. It's not that I'm making a random.
Ambiguous to the court. It is not clear to the court also. At the time of passing the order.
Yes. It was. It should have been clearer. It was ambiguous. And now that they've brought it, they are saying that it's an admission. I have a right to explain it. I might have said something. I'm not saying I didn't say. It's written there on a paper that I have said.
According to you, there is a misinterpretation.
Omission. Yes, it's a misinterpretation. It's not an admission.
Because of your ambiguity. you should be unambiguously stated, you must have unambiguously stated 10 to 15 for the year this and this.
Yes.
That you have not
No,
mentioned.
that was what was argued before the special law. When drafting this, it has just gone down as we have said at best. I'll read that paragraph. It's not
That's it.
saying that I am liable to pay that. We are saying that the special referee hasn't considered my evidence. The defendant with all documentary evidence has proved that the ground rent for the subject premises can at best be 10 to 15 rupees per square foot. So we are referring to the evidence we have given. We have proved before the authority. Now, my learned friend says you have argued that you are stuck. You have to give a decree for that. That was my argument.
You give that argument, notes of argument,
Yes,
notes of argument, Mr. Bose.
Okay, to add to.
Would you like to add something?
I would like to, these submissions, one is that this is not, they are not seeking strictly a decree. They are asking for a direction to be secured.
Whatever that might be, you want to file for the notes of argument. It is not filed
Yes,
today.
if I may, I can file this.
Or come
We
with
can
the
give a
complete one. Otherwise, it will be another misguiding thing.
Very well.
May I quickly respond? We have not been favored with a copy of the note. I wish
It's not being filed.
I'll give.
I had asked Mr. Bose for a copy of the note so that I could respond. Mr.
No, it will
Bose,
be not filed today.
When I write it, I will give it.
may I just immediately answer the point so that we may file.
Absolutely. I will hear from you.
Kindly
I
come to
don't
page
see.
133 once. I'll be very brief.
133 of?
Of
No.
petition.
Before my learned friend, before he replies to us, now on this unambiguous and equivocal, I want to show two judgments. I'm sure my learned friend knows this, but Uttam Singh Dugal, which says that it has to be unambiguous and unequivocal. And an admission can be always
File it with your
explained.
notes of argument.
So those two judgments, I'll put my learned friend on notice. I'll give it with the note.
Which one application?
GA11. That is what your lordship has been hearing. Well, the first thing is, the suit is filed for mean profits in 1995. My learned friends dispute their obligation to pay mean profits, saying that they have never overstayed their welcome, right up to the Supreme Court. Ultimately, the Supreme Court says that no, you're in wrongful occupation, you have to pay mean profits. Now, the special referee has now deliberated on this, come up with a figure. My learned friends, we said that yes, while your lordship is considering the passing of a decree in terms of the report of the special referee and my learned friends challenge to the special referee's report, but your lordship will kindly direct them to make some payment. Now, my learned friend makes technical, hyper-technical, over-technical arguments. But what is my prayer? Let us understand that.
To get some money.
Today, since 1995, I am out of pocket. They have occupied my property but not paid me since 1995. That obligation arises from there. Now, I say that since you're not disputing this part of the quantification of mean profits by the special referee, why do you not pay it? Now, my learned friend says then that this is, Mr. Bose, I was a little surprised to hear him argue that this is not an admission made by the defendant. It is in fact an admission made by the plaintiff. It's a typographical error. Now, I would imagine that if it's a typographical error, then you correct that error in your affidavits. Now, I draw this court's attention to this admission that is made in my petition. To that, my learned friend files an opposition, not said this is a typographical error. To that, there is a reply file. Now, here, not only does it not say it's not a typographical error, it also says in the affidavit, it's an inferential admission. Now, inferential admission is also something on which the courts have spoken. Said inferential admission is also admission. Now, the whole object of a public limited company, like the Indian Oil Corporation, is to deprive this person of what is even by their own admission due to it. Now, the question is it an admission? First of all, this is what it says. The defendant with all documentary evidence and with established procedure method of calculating rent proved, my learned friends proved, according to them, that the ground rent occupational charges of subject premises can at best be 10 to 15. Now, even if I read this at best word, it can't be less than 10. Now, today, my learned friends, this is ambiguous. This is not clear. Now, what is not clear? he says the defendant, that is my learned friend's client, my lord, proved with documentary evidence. So, my lord, he relies on documentary evidence that the rent, my lord, can at best be 10 to 15. Now, my lord, even if I say 15, which I say is not, my lord, in controversy at all, I'll show you, lordship, why. 10 is not, my lord, in dispute. Now, my lord, first of all, my lord, my Mr. Bose's submission that, my lord, this is in fact a typographical error is not pointed out in the affidavit. It is not open to him to, my lord, make this submission from the bar. That's number one. Number two, my lord, kindly see what they say about the admission. They say it's an inferential admission. I just want to show you, lordship, that one, my lord, portion. My lord, in paragraph 7 of the opposition, I'll read it out. I'll, my lord, put it in my note. The statement referred by the plaintiff can merely be considered as an inferential admission.
Mr. Shah, let him file, complete his argument. Let him file the notes of argument. Then I will hear you reply. You come with all notes of argument.
Well, if I can be given a copy of his note, then I can prepare my note.
Not yet filed. He will file.
I'll
He will file.
I'll give them the copy when it's finalized.
Definitely. Before that date, you must give a copy.
Because then, my lord, what I can do is, my lord, if they give me a little in advance, I can prepare my written notes and also, my lord, approach your lordship.
Only one last thing. My learned friend, only to impress my lord, has said that we haven't paid them a farthing. 2 crores they are holding of our money. We have paid during 91 to 94.
Come
We
with
have
the notes
paid.
of argument.
No, we have
Have they
paid.
done charity?
No, that was the rent payable. The last paid rent we have paid. So please do not say that we have not paid.
Mr. Shah, if you
Number
wait
one
about
and number
money.
two, in the reply,
My lord,
we have
I learned,
explained this.
my lord, his magnanimity knows no bounds. We know he's very, very generous. My lord, he doesn't want to pay me 10 rupees.
We have put in the
Does
10
not want to
rupees.
make it
Let him
15.
take it.
I can show you, lordship, that the Supreme Court, in respect to the same premises, has, my lord, approved a report of Talbot and Company at 45 rupees.
Not 60.
Heard Mr. Bose appearing for the defendant in this case, in part. It is submitted by Mr. Ghosh that a written notes of argument will be filed soon, detailing and discussing the points raised. The same should be filed before the returnable date, and advanced copy shall be given to Mr. Shah, the learned counsel for the plaintiff. The matter will appear in the list on 8th August.
8 August. Very good.
8th, check it.
9th
August.
9th August. Very good.
9th August. Next item.
Item number 9.
Your Lordship, I am appearing for the plaintiff, Your Lordship. Your Lordship, notes have been exchanged between the parties in this matter, Your Lordship.
Have you filed those?
Yes, we have also filed our notes.
Let me have it.
Lord, yes, I appear for the defendant. My argument is correct that notes have been exchanged. As far as their note is concerned, I was under impression that it has not been supplied to me. Today morning, I came to know
Has been
that it
supplied.
was supplied. And my lord, I want to make a little submissions, my lord, on the basis of the note. Since my learned friends.
Today, would you make?
My lord.
Today, would you make it today?
No, not today, but I have just got the today itself. It's not the fault of my learned friend.
This is for the defendant. You are defendant.
Plaintiff.
I have also given my notes, my lord.
This is defendant's note.
I have given also my note.
No, defendant.
This is
Your
my
Lordship,
note.
for the plaintiff, I have also given, Your Lordship.
Plaintiff's note.
Taken away.
Both the counsels filed their respective notes of argument. The learned counsel for the defendant submitted that A supplementary notes of argument is to be filed on behalf of the defendant and craves for accommodation and prays for accommodation. Let the matter appear in the list for further argument on 10th August. 10th August is okay. 10th August.
Item number 10 and 11.
My lord, I am appearing for Nadiwala Investment Company, my lord. My lord, I have submitted on last occasion, my lord, the few of the defendants have died, my lord. And my lord, I have also given the particulars of new partners of Nadiwala Investment, my lord. I have given particulars, my lord. Now, my lord, your lordship directed me to supply details of legal heirs of the deceased persons, my lord. My lord, I am only appearing for Nadiwala Investment Company, my lord, which is a partnership firm, my lord. I am not appearing for other defendants, my lord. I am unable to, my lord. I tried to ascertain, my lord. My lord, I am unable to provide the details of the other.
Is the firm reconstituted?
Firm reconstituted. I have given details of the new partners, my lord. The present partners detail I have already supplied, my lord. By this letter, my lord, I have supplied the details of the.
In that case, insofar as item number 10 is concerned, you have to make necessary filing.
Yes. My lord, item number for the first matter, my lord, there is only one defendant. There are, my lord, there is
No question of
requirement-
substitution.
There is no requirement of substitution or, my lord, deletion. Item number 11, my lord, this is concerned, my lord. Substitution or deletion of the name of the parties, my lord.
Have you given it to the other side?
Yes, this is addressed to the other side, my lord.
So you have to file application.
Yes, my lord, but they have not supplied us the death certificate of defendant number 2, 3, and 4, being the who have partners expired earlier, my lord.
They were the partners, my lord, of the firm, my lord. I am only for defendant number 1. Well, rest of the parties I am not appearing, my lord. My lord, they have to take steps in accordance with law in this case, my lord.
Partnership firm is reconstituted.
Partnership firm has been reconstituted, my lord. I have the knowledge that they have died.
Same name is there.
Well, they have the deceased partners have my lord.
You ask from them.
Yes, my lord. Defendant number 2, 3, and 4, and 8, my lord.
Yes, you call for them, ask from them the death certificates.
They have to contact the family members of the deceased persons, my lord.
Either you have to do it or I will pass direction to KMC to furnish you copies of the documents.
Very well, my lord. In the meantime, I will do exercise.
Yes. So today, what will you do? Today adjourn the matter?
Yes, my lord, for 2 weeks at least.
With the direction upon the plaintiff in CS 770 to take steps in accordance with law, my lord.
Learned counsels of both the parties praised for adjournment in order to enable them to file appropriate application to further proceed with the suit. Accordingly, the matter is adjourned to 23rd August.
Yes.
Both the suits are adjourned to, not matter, both the suits.
Yes.
Item number 12.
But suit for the services rendered and not paid. A very old suit of 1990. The amount claimed is also very small, a very paltry amount, a very old person. The amount is 5 lakhs and odd. If your lordship kindly gives me 2 weeks time, I'll tell you which stage the suit is in. The examination in chief of the plaintiffs of the plaintiff rather, not the plaintiff's witness, but of the plaintiff had started and was almost on the verge of completion. Then the state appeared and filed an application for revocation of leave under clause 12 and for dismissal of the suit. That application was disposed of, rather dismissed, and now the defendant
Suit was dismissed.
No, the suit was not dismissed. The application was dismissed.
Application was restored.
Initially, the application filed for revocation of leave of clause 12 and for dismissal of the suit, both prayed in the same application. That was dismissed. That application was dismissed.
GA3 of 23 for restoration of the suit.
Oh, that is subsequently when the suit was dismissed for default, and
Yes.
finally, your lordship was pleased to restore this suit.
Yes.
Now, if your lordship kindly gives me 2 weeks time, I shall come back with the witness, the plaintiff. He's a very old person, my lord, and his examination chief is almost on the verge of completion.
Mr. Sinha prays for leave to file application for allowing him to file written statement.
My lord, at this, my lord, this suit is of 1990.
Separate
But
issue.
whatever
It is
Mr.
separate
Sinha wants to do, my lord, let him do, my lord. I shall, my lord, proceed with, my lord. I believe, my lord, there are orders to that effect. Where, my lord, the filing of the written statement was denied. But I shall, my lord, check up the records and, my lord, tell your lordship, my lord, with regard to that aspect, whether at all, my lord, that is there or not. But I shall not make
The
a
learned
submission on the bar.
register original site shall submit a report on the next date on date of service of summons, date of appearance of the defendant, whether any written statement is filed or not,
No, written statement has not been filed.
date of appearance of the defendant in the suit. The report shall be submitted before the returnable date. Full stop. The learned counsel for the plaintiff submitted that
Well, the state is appearing, not the defendant, the only defendant in the suit.
Lordship in this matter.
what is the status of the suit?
Yes.
Well, the examination chief of the plaintiff was going on. It was almost on the verge of completion. So, Mulad kindly gives me some time. I'll Mulad complete the Mulad examination in
Your
chief.
Lordship in this matter, you have already affirmed a written statement, Your Lordship, and that's
Written statement?
written statement, Your
No,
Lordship.
no, you prayed leave for allowing to file written statement. Written
Yes.
statement was not allowed.
Yes.
You file application praying for allowing him to file written statement. For the application,
Yes.
I allowed leave to file application.
Lordship kindly gives us only 5 days time because this is ready, absolutely.
Mulad,
ready.
First, you file application. Let me call for report from the register original
No,
site.
that has not been filed. I am asserting. So there's no report.
When did you appear?
On the last occasion, Your Lordship.
No, they were appearing Mulad during Mulad the examination in chief. They filed an
Let me
application.
know whether the
Yes,
statutory
Mulad.
time is
Yes,
expired
yes,
or
of
not.
course,
We
of
had
course.
appeared. The order should show that we were appearing.
It's not a question of when did you appear. That we have to know. I have to know
উনি
when did
একটা
you appear,
report
when
call
someone
করেছেন
was out.
register থেকে সেখানে আসবে কোনো। আমি in the meantime Mulad, I'll bring my witness for Mulad examination. Mulad.
Kindly allow some time.
The learned counsel for the plaintiff 6 time for examination of witness. The matter is adjourned to 11th August.
I'm grateful.
Obliged.
Instead of 11th of August, can it be Mulad the week thereafter, Mulad? After 16th, Mulad, if your lordship be kind.
29th August.
I'm grateful.
Item 13.
My application, my lord, I apply for the plaintiff.
But
to,
I am for the
this-
defendant, my
my
lord.
lord, this is
Before my learned friend starts, my lord, only one thing, perhaps this application is not maintainable. It is the application for substitution by them. Defendant number 1 died. We had informed they had to substitute, but perhaps, my lord, this is not maintainable in its present form. My lord, kindly come to the cost title at the first page. And that's why, well, the plaintiff number 1, Ava Pine, Lordship has already directed, Ava Pine already died, my lord directed her substitution. I have been informed that department has already carried out the substitution. So the name of the Ava Pine, my lord, perhaps this is not maintainable.
The application is GA.
GA,
So application number 3.
GA11, my lord.
that was GA10 on
That
which
was GA10, but this one is GA11. I am referring your lordship to GA11, my lord, first page. The cost title, my lord, kindly see the plaintiff number 1, my lord, Abha Pine. She died, my lord. Though after 3 years, but my lord allowed them to make the substitution, my lord. And Abha Pine name has been substituted, my lord. But this is appearing, my lord. So, my lord, perhaps this application is not maintainable in its present form. And this is the first thing I should say. And my lord, there is also one
Yes, my name is substituted. This is
already done.
yes.
But this is not maintainable in its present cost title, my lord. I think, my lord, because already Abha Pine has been substituted. But the cost title
But
doesn't
what
say
happened
so.
in-
Then I boleni.
Yes, your cost title is to be changed. You can take it with the plaintiff.
may I?
There is also another fault on my part. I must, my lord, though it is an inadvertent mistake, but it's my duty to point out to your lordship. That was our fault, my lord. Kindly come to page 10B, my lord. Lordship will find a letter. But the letter was given by our advocate on record, my lord. Though he has given the name of his client, my lord. Kindly see my client's 10B. Mihir Mohan Pine, Shima Pine, and Girin Mohan
Your
Pine.
client Abha Pine, that should not.
No, no,
be-
his
No, no.
client Abha Pine.
His client is defendant number 1. He's appearing for defendant. This is the substitution application of defendant number 1.
আমার কেসটা আমাকে বোঝাতে দাও না ভাই।
And perhaps what my learned
My lord,
friend is saying, my lord,
Hmm.
he has not checked the pleadings at para 6. He has not checked that.
My lord, I don't know why he is interrupting. Lordship is giving.
This is
chance
my
about-
application.
Yes, but
Kindly
I'm
seize
taking a
the.
point
Just
of
a minute, let me go through the application.
When this was filed, this has not taken effect.
But
That I have already said.
I've taken a point.
Yes, you have.
Yeah.
But subsequently,
but
it
in
has,
your pleading, but it is in your pleading
yes,
that the plaintiff number 1 expired.
yes,
There was substitution.
yes.
But why have you not carried out? the
No, but
substitution?
by that time, the department has not carried out. When this
Order?
was filed, it was not carried out. It was subsequently carried out after filing the application.
Withdraw it and with a file liberty. to
So
file
kindly
it.
gives me liberty, I will just withdraw it.
For technical reason, the learned counsel for the plaintiff.
Plaintiff.
Plaintiff craves leave to withdraw the application to file it afresh. Leave is granted. GA 11 of 23 stands disposed of as withdrawn.
And perhaps my learned friend has given the clear instructions who are the legal heirs. That is no dispute, hopefully.
Come with a new
So far as GA 10 is concerned,
G10 has already been disposed of.
G-
This is G11.
GA 1,
GA1 is our injunction application. That is pending. That will be there.
Let him come. But
when will you be able to file it?
My lord, if the instruction, because I don't know whether he is coming out with a fresh instruction of legal heirs,
yes,
if- then he has to give me. Otherwise, how can I?
Learned counsel for the defendant shall furnish proper information
as to legal yes. We in a course of 2
for
days.
making necessary application for substitution. The matter will appear in the list on 23rd August for further order.
Grateful. Lord.
23rd August, my lord.
Estimated suits.
Please, your lordship. My lord, I appear on behalf of the propounder. My lord, on the last occasion, it was
Please to
your,
other side.
my lord, my learned friend is there for the caveatrix.
My lord, there is a direction to file the judge's brief of document and the issue suggested. I am filing.
My lord, we had filed our suggested issues, my lord, on behalf of the plaintiff propounder.
Where your suggested issue is?
My
Your
lord,
suggested issue?
I have given the suggested issues also. And I have the copy to the other.
Today it is not mentioned for framing of issues.
My lord, today your lordship was pleased to fix it for framing of issues. And my lord, your lordship also directed the propounder to make a formal application for appointment of a commissioner. Inasmuch as both the attesting witnesses are residents of outside the local jurisdiction, they stay
the
at
issues be
Varanasi.
framed.
Yes,
Come next day.
thereafter, my lord.
Send it to me
Oh.
in my chamber.
Issues your lordship will be
I'll
pleased
frame
to,
it.
oh, your lordship will be pleased to frame them. My lord, only one thing, my lord, may I just indicate the issues that have been, my lord, suggested on behalf of the defendant. My lord, with regard to issue number 1, if your lordship kindly comes. What was the relationship between the testatrix and Ram Iqbal Dubey? My lord, Ram Iqbal Dubey is the propounder. That is, my lord, they are alleging that Ram Iqbal Dubey was a servant. And we are saying that the testatrix used to look after Ram Iqbal Dubey as her own son. That, my lord, matter of merits we have to prove. But there was a relationship. So, my lord, this issue, we do not have any difficulty with this. But with regard to issue number 2, my lord, your issue has been framed in the manner that what was the relationship between Srimati Maya Chatterjee and the testatrix, Dr. Aparna Chattopadhyay, deceased. Maya Chatterjee is the caveatrix. She is claiming to be the widow of the brother of the deceased. Our case is that she is a nobody. She does not have any relationship with the testatrix. So I was only, my lord, praying
that if it could be said that was there any relationship between Srimati Maya Chatterjee and the testatrix?
Necessary issues will be framed.
My
It
lord,
will not, necessary issues will be framed. It will not be copy paste.
no, my,
Framing of issues is not copy paste from the both the parties suggested issues.
and my lord, with regard to the application, my lord, and the application for commission that we are to move,
Let me frame the issues. Then you make it mention, file an application.
we have, on the last occasion, your lordship
Is it
directed,
filed?
yes, it's here before my lord.
Okay.
It's here before my lord. We have filed it. Pursuant to your lordship's direction, we filed it. It's, yes, it's 6 of 2023, my lord. It's a very formal application pursuant to your lordship's direction. If your lordship kindly comes, my lord, from paragraph
Have
4,
you any objection with para 22,
the petition.
page 8?
My lord, I have no objection if she is admitted as a commissioner. But there is some difficulty to prove the defendant's advocate to the Varanasi because the defendants have no monetary issue is there. They have no sound in monetary balance. So if the defendant's advocate is going to go to that Varanasi, it will be difficult for them to afford. So who will afford the cost of the defendant's advocate? This is the
We have to afford that we are ready. We are already expressed. It's our cause.
It will be reflected. in
All right,
the
that
order.
will be done. So far as the name is concerned,
It's concerned.
Suchit,
I do not know the.
she's a member of the bar, man.
We do not know the name of the runner.
I do not know personally.
She's a member of the bar. She appears before my lord also. My lord, we had suggested the name only because she's acquainted with the suit procedures. She's a young member of the bar. Your lordship may inquire, my lord. So your lordship was pleased to.
if you have any problem,
What I am on, let this matter appear another day.
No, my lord, it's only procrastinating.
issues I will name.
Be present, the runner advocate.
No.
Present on
My
that
lord,
day.
Shuchishmita Ghosh Chatterjee regularly appears before my lord. I wouldn't know as to whether your lordship will be able to recollect. She's a member of the Bar Library Club. She's a.
Let her be appointed.
Yes, my lord.
My lord, only one thing will be reflected. My lord, who will afford the defendant's advocate? They have told that
They will be here.
Only one council, my lord.
One council,
One
yes.
council.
Should be reflected.
Yes, that we will. And my lord, one more prayer. My lord, your lordship will kindly come to paragraph 24, the last portion, that the orders, appropriate orders may be passed. My lord, prayer 3 we have set out. With regard to the records, we handed over, my lord, to the advocate and record. And my lord, thereafter, again, after the commission or the commissioner, and the commissioner will give that.
All right. Copies of the order, copies of the record, not the original record, copies of the record.
As your lordship, please. As your lordship.
Send me to my chamber. Send me to my chamber. Particular.
For orders.
Oh, for orders.
I cannot 15.
I will pass order.
My lord,
I will frame issues and pass order.
as your lord.
When it will appear? When it will appear?
When check my order. You must have some patience to write me the order.
Item 15.
Why it is for order?
Mother, item 15, Mother, your lordship may kindly take up your lordship's last order of 15th May 2023. Mother, in this matter, my lord, I appear for the plaintiff. My lord, the suit filed. Now the suit was decreed, my lord.
Special referee shall finalize the proceeding.
Yes, my lord.
Where is the special referee?
My special referee is not appearing, my lord. What we did, my lord, after this order.
Or depending, my lord.
After this order, my lord, we have served 2 letters intimating this order And thereafter, again, a reminder was sent to her. There is no answer to it, my lord. The proceeding before the London Special Referee is on the verge of completion. It will take only 1 or 2 days to get it completed, my lord. The decree was of 2014, my lord. Appeal filed, SLP filed, therefrom all settled, dismissed, my lord, by 2017, my lord. Thereafter, the proceedings before the London Special Referee was going on, my lord. 1 minute. Landed special referee was going on, my lord. There, my lord, the defendant filed an application for recalling of the witness, my lord. After elaborate witness was taken, my lord, evidence was taken. Now they filed an application for recalling of the witness, which was dismissed, against which they prefer an application, my lord. That was also dismissed by the Honorable Coordinate Bench. And from it, they preferred an appeal. It is also reflected in your lordship's order, my lord. The appeal they filed in September 2022, my lord. They had not taken any step to get it heard, to get it listed or to get it heard, my lord. So there is no stay order also. In that view of the matter, my lord, your lordship was pleased to pass this order of 15 May 2023, my lord. We are suffering since 2014, my lord. Let there be a preliminary direction on the
No, I am not.
special referee.
The appeal is not listed because justice, I think.
They have not given a single
Let him
notice.
now. I have only called for a report from the special referee. Let the report call for. There will be a report come. Report was called for from the special referee. In terms of order dated 15th May 2023. Neither the special referee is present, nor the report is submitted. The learned register original site shall communicate a copy of this order as well as the order of 15 May 23 to the special referee.
Prior to that, there was an order of your lordship of 8 September 2022, whereby your lordship was pleased to direct the special referee to expedite the proceedings.
Must be present with the report on the next date. Let the matter appear in the list on 18th August.
18th August. Great. My lord, these 2 letters, your lordship will be pleased to keep it written with the records, my lord.
You keep it with you.
Very well, my lord.
Rather, you furnish a copy of this letter to the register original site.
Register original site.
Because register original site is directed to communicate this order to the receiver, to the special officer.
Very well, my lord.
So the register original site may need the details of the special referee.
Very well.
So you furnish it.
Very well. Grateful, my lord.
All suits, item number 22.
Sir, I appear on behalf of the plaintiff and the respondent in the
Here
application.
of the petitioner with that this is an application for setting aside of a consent decree, my lord. I'm led by Mr. Shorkat. In that matter, they're raising a point of limitation. My point is that, first of all, this is a void decree. The agreement is a void agreement.
Where is the application?
And we have also filed an application today.
This is GA 14.
GA 14 for interim order because they are proceeding with the execution case. GA 15.
We're not proceeding, my lord. It had come up, the execution was filed, it had come up. And it was.
Let me hear him.
Very well.
Why you are intervening?
Sir,
Led by
This
Mr.
is for consent decree, setting aside consent decree.
Lordship.
Dated 11 December 2015.
Yes, Lordship.
And restoration of the suit.
Yes, Lordship. And because, Lordship, our main point is.
What are your grounds?
Ground is fraud. And another thing is, from the records, it will find, Lordship, that this decree is a void decree. Because the property is the property of the deity. The deity is not represented. The deity did not sign. And it was declared that the property is out of the.
Yes, it was submitted that last day.
Lordship, your call, Lordship, kindly, that will be clear from that.
When the decree was passed?
2015, my lord.
When this application is filed?
2022, my lord.
So, whatever the time limit?
Lordship, this is my first case will be, this is a case of fraud. Fraud I came to know in 2018.
Which para?
My lord, your lordship kindly takes up paragraph 1. Lordship kindly.
Just a minute, second. Right. Lordship kindly comes to paragraph. Lordship comes censures the terms of settlement, decree, paragraph 13. Possession. Lordship paragraph, come to page, paragraph 15. Lordship. Where we have given the consent decree was passed on misrepresentation and fraud. We have given the instances, and that was in paragraph D, my lord. It's page 19, my lord. We have said that it is fraudulent and it is prejudicial to the GA number 2018, that is paragraph 15B, page 20, my lord. Where a lot
GA 14 is for setting aside.
setting aside.
Where have you mentioned the date of the time or specific point of time when you came to know of this?
My lord, kindly come to paragraph 15. Instance of kindly take up paragraph B. In the month of November 2018, I've taken the specific point, my lord. I've taken the specific point of it's a for.
Is that case where valuation?
Evaluation was one of the issues, my lord, and subsequently we also find from the documents disclosed that this deed, this agreement is a void agreement because it's in respect to the property of the deity, and since the next
Deity being represented.
deity being represented, my lord, and there is till date there is no next friend of the deity, my lord.
That all you have also mentioned in para 17 also.
Yes, my lord.
November 2018 came to know. Yes, what do you have to say now?
Lordship, only one thing I want is, first of all, Lordship, the very important aspect is this is a, if your Lordship takes up the plenty once, in the plenty, your Lordship will see there was a next friend of the deity. The next friend of the deity, and the prayer was for a declaration that the property is Debottor. And we don't have any right. The terms of settlement that was filed was for a declaration, for a saying that the property is Fipom Debottor and the deity is not a party. That is one thing, Lordship, I want to place before your Lordship.
Where is the compromise decree?
Lordship, the compromise decree is at the GA 14, Lordship. Lordship kindly first takes up the plenty, my lord. The plenty starts at page 64A.
Now come to the compromise decree. Where is the compromise decree?
And the prayer, Lordship, may I show the prayer once? The prayers, Lordship, the prayers are at, the prayers your Lordship will find. If may I show the prayers one, then I'll straightly come to the compromise decree, my lord. And the prayers are at page 86A, my lord, the prayer. 86A, the prayer.
Yes.
A declaration that immovable property mentioned in Schedule A to the plenty, namely the property in Benares in which the plaintiff number deity is installed, and the properties of Calcutta being premises number 2/1 and 2/2 Madhuset and Calcutta, and premises number 12 Hashmukul Lane, in the aforesaid jurisdiction are absolute Debottor properties belonging to the deity.
And framing of scheme.
And framing of scheme, my lord. And your Lordship has seen the cause title. The deity was represented by a next friend. The next friend has died. There is no next friend of the deity. Now your Lordship kindly takes up the compromise decree. The decree is at page, Lordship, the decree is at page, annexure H, page 103, my lord. If your Lordship comes to page 106, by consent of parties, my lord. By consent of parties, the suit is being treated as appearing on day's list on 15th day of May in the year 2015 for final disposal before Justice so-and-so. One of the judges of this court, in the presence of the advocate appearing party, a sufficient court fee so-and-so, it is declared that with the consent of the parties by the signature of the plaintiffs 2A, 2B, 2C, 2D, 2E, 2F, 2G, and 2H. The plaintiff number 1 is not signed. And the most valuable property of the deity, the property in Calcutta, in Boro Bazar, was declared to be free of Devottar, my lord. That's why it is very important that the report must be sought for who is representing the deity.
Who signed it?
Signed all parties except the deity. All party except the deity.
It is represented by the Shevites.
No, this shoot was not by the Shevites, my lord. The shoot was by the next friend. The date shoot was against the Shevites. Alleged next friend, my lord. She claimed she has died.
Who are Shevites?
The Shevites are the, my lord, defendants, my lord. Defendants. May my learned senior take over, my lord? I'm plenty to get this. My learned friend, my senior.
Let him continue for some time.
Yes, of course, madam. So the deity was in the till date, the deity is not represented, my lord. And his property is being taken over, saying it is free from the Devottar, my lord. Even this next friend was not appointed by the court as is required.
Venerous property shall be continued to be Devottar property.
Yes, and the property in the occupation of the plaintiffs, which is the most valuable property, Bow Bazar, it is declared that is situated at Calcutta and Madhuset Lane, and so are not Devottar properties to be declared free from Devottar.
The suit was to declare the.
And the suit was that the property should be declared that Devottar, and we have no right to interfere. So abandonment of claim of the portion of the suit, my lord. Contrary to pleadings, contrary to the order 23, and it is not binding on the deity, my lord. His property is going away. Somebody must represent the deity.
There is your problem. Page 109.
Yes, my lord, my main problem today it was 109. My lord, plaintiff agrees to purchase. My lord, today if this
1 crore 70 lakhs, that is your point.
The problems commence because what happened was, lordship, this was 1 crore 70 lakhs.
Yes, that's right.
Decree.
That's what I'm saying.
In 2000, this decree was of 2015, my lord.
So your point is it's undervalued?
Why I'm saying, my lord, what has happened is, my lord, they in 2018 when they went for a conveyance for the valuation, my lord, state declared that the valuation is 12 crores. First is undervalued. The second more important problem is, lordship will see from the terms of settlement that this money is to be used for the deity. Now what is happening is, for this 12 crores as a seller, the deity will become liable to pay tax of 3 crores.
Why deity will be liable? Because here it is mentioned it is free from Devottar property. It's not a Devottar property.
Not that.
Why deity will be liable then?
I'm an undervaluation, because if your lordship looks at the.
When this decree was passed, consent decree was passed,
Yes.
consent decree declared that these three properties are not Devottar properties.
Lordship,
So why did you will be liable?
Lordship, deity will be liable because, Lordship, deity
Under
will be
section
liable,
50C.
deity will be liable because, Lordship, even in that, when they make the requisition for valuation, there the seller is the receiver for the deity.
Section 50C.
And under section
Page
54,
146.
146, I've given that there will be, today this money may come to me, may come to the deity. If I am the seller, this money is to be utilized by me for the benefit of the deity.
Why?
That is the terms of the settlement. That is the terms of settlement.
Where it is mentioned?
DT will be liable.
No, then it does need 12, Lordship. Kindly page 110. The entire sale proceed will be kept in the name of deity and derived from the will be placed.
146.
122.
And 146, my lord. What do one keep for the deity? 296 is the tax that I have to pay under section 50C.
Registrar has value.
40. And 142 is a registered valuation, my lord.
So this will go to the DT of Varanasi.
Yes. Who is the owner of the property? As for the plant.
And the liability is on the DT of Varanasi.
Yes.
Getting 1.70 crores, paying 3 crores. Plus 300.
Lordship, may I let him know?
These properties were dedicated for
the Shiva Puja of the deity.
At Varanasi.
There were 3 properties, my lord. 2 properties in Calcutta, Madhoset Lane and Hashpukur Lane, and 1 property in Varanasi where the deity is situated, my lord. This in 1850, in the 1800s, these properties were given to the deity. It was given in the name of the deity, my lord. The next, we are the Shivaites. The next friend, the person who is claiming as the next friend, is one of the daughters.
All right, I got your point. Yes. Now you come to the things to say.
2 more documents, Lordship, can you see? Page 1. That to me, 142.
140, my lord, 142, your lordship has seen the valuation.
Valuation, I've seen the valuation.
Then 146.
And 146 is the tax liability report, my lord, that the EA has given us.
46.
146.
All right. Yes, yes, my lord.
So it is contrary to the interest of the DT.
My lord, we've heard our submissions of our learned friend. I will hear you now. Pending for long. First thing, I will suggest you to pay the balance. Balance means the particular loss they are suffering. Why don't you do that?
There's no loss. There's no question of a loss. First,
Income tax has imposed liability.
First and foremost, they have to overcome the hurdle of section 5 and section 3. If they have filed this application beyond the period of limitation, they have to overcome that threshold. Only then the question of the application being maintainable can be gone into. The application they have come up, my lord, the decree. What will kindly see the date? They have not explained as to why the delay. Now what they are relying upon?
According to them, they came to know in November 18 and this is filed
in 2022. 4 years. And for recalling 4 years, it's not 3 years that is applicable. 30 days is applicable. My learned friend proceeds on the basis of Article 137. Article 137 is a residuary provision where there is no other provision provided for in the Limitation Act. Limitation Act provides for recalling.
So your point is, even if we resort to 137,
yes,
then also
even then barred.
57, I think.
Yes, my lord.
No, not 52nd, 7.
This will come under the head of applications. Lordship comes to Article 123.
That is ex parte.
Here, if in case of an ex parte, it is 30 days. In case where it's passed on terms of settlement, would it not even apply?
That is your first theme of argument.
Well, I'm led by Mr. Chaudhary, my lord.
Lord, please take the application to open the gate and will not to come in. My learned friend would have to get over, my lord, and obtain an order in terms of prayer A. Lord, please look at page 23. The petitioner is aware.
Page
23.
That is para 21.
No, my lord, page 23, the prayer A.
Delay.
Yes. My lord, the petitioner is aware.
That is your application. That is your
That's
contention.
their application.
That
They
what
prayed
you
for
have
delay. Now, my lord, they prayed for condonation of delay. Now, my lord, please look at the averments. Paragraph 16, that we have received them, then 17, then my lord 18, consent to the terms of settlement was caused by fraud or misrepresentation. So the agreement becomes voidable and the compromise entered into is unlawful, same is liable to be set aside. Then, my lord, paragraph 20, the decree passed on compromise, etc., should be recalled, 19 and 20. Now, paragraph 17 at the end, top of page 22, third line, the defendant's petitioner's claim.
Which page?
Not page 22.
Starting with counsel.
Yes, my lord. Second paragraph, second sentence, no part of the defendant's petitioner's claim made in this application is barred by the laws of limitation. But for abundant caution, the defendant petitioner prays before this honorable court for condoning the delay, if any, in filing this application. Now, my lord, for this is a suit which has been decreed. The application for setting aside of a decree. Limitation applies on all fours under the Limitation Act, which is why, my lord, this averment is there. Now, either the petitioner has to say that limitation does not apply and make submission, so show some authority for that, or the petitioner has to come and tell your lordship that yes, limitation applies, but this is my case made out in the petition for condonation of the delay, for allowing prayer A. In this case, my lord, neither has happened. No, petitioner has not, my lord, shown your lordship that limitation does not apply. My lord, kindly take, my lord, the Limitation Act.
59. Article 59 you are referring to.
59 is for, my lord, cancellation of a document. If
Or
my
decree.
recollection is correct. It's not to cancel or set aside an instrument, exactly, my lord. Set aside an instrument or decree for the rescission of a contract 3 years when the facts entitling the plaintiff to have the instrument or decree cancelled or set aside or the contract rescinded first became known to him. Now, my lord, limitation starts from the date of the decree. If after, my lord, 20 years, my lord,
First became known to him.
First became known to him. It's not that
You might argue that it was in November 18th, so it was filed thereafter.
because limitation starts from the date, my lord. The calculation starts from the date of the decree. This is, my lord.
Here says date of knowledge.
Yes.
Now, even according to him, according to your junior,
Yes.
even it is filed after 3 years after date of knowledge.
But from the date of decree, my lord, the pleading has to be there. And this is a ground for, my lord, condonation of delay. I will come and show the authorities on that subject also. So, my lord, therefore, whichever way your lordship sees it, my lord, it's, my lord, 3 years is over. That's why, my lord, advisedly so, prayer has been made. That's why advisedly prayer has been made. And there is nothing, no pleading for grant of prayer. Condonation of delay, your lordship.
No, there is a pleading, but grounds are not enough according to you.
Yeah, no grounds. No plea. They haven't pleaded what entitles them to condonation of delay. Your lordship will look in vain.
Explanation. You can say
No
there is no
explanation.
explanation.
That's the correct.
Ground is there, but there is no proper explanation. According to your submission.
According to my submission, there is no ground, which is why there is no
Or
explanation.
delay is not explained.
Delay is not explained. It has to be explained day to day.
All right.
Nothing is there.
All right.
Now, my lord, to my lord reiterate, I'll just cite the authorities. Lord, kindly give me one moment. They're still looking for the judgments. I'm really sorry.
Do one thing, come tomorrow.
I'll come tomorrow. This is
Or
not
day after tomorrow.
day after tomorrow. I'll come day after.
Day after tomorrow is 21st.
Yes.
No.
25 বন্ধ থাকবে সব কি বলছি মানডে রাত তুই আসতে পারবি
I'm sorry, what I do is that I come
On
by.
21st.
I can come if Mr. Sarkar comes, I can come. I come early. I come by 8:30, and I sit here till 7 o'clock. That will peacefully some hearing matters you can do. I can come.
No,
If
Mr. Sarkar will not come.
21st
Then at
tomorrow
his convenience.
tomorrow or
Heard Mr. Chaudhary in part. Monday কি আছে দেখো। 24. Monday is 24. 24th for further hearing.
আপাতত আছি বল এইভাবে বলি
Item 23.
My lord, I appear for the Administrator General and Official Trustee, my lord. We are ascertaining the report, my lord. Kindly gives us 2 more weeks time, my lord. Just because it's a old matter, my lord.
Adjourn to 17th August.
Grateful, lordship.
Item number 24 to 30.
My lord, these matters are filed by the University of Calcutta. My lord, we have already taken no objection from the erstwhile advocate, and we are yet to file the Vakalatnama in these matters.
Adjourn to
My lord, may kindly fix these matters along with the above matters, the earlier matters, item number 4 to 6. On 10th August, your lordship has been pleased to fix.
not 10th August. So many matters will come. 24th August.
Grateful to your lordship.
Old matter road দিও না।
Item 31.
Appearing for the plaintiff in this matter.
My lord, I am for the defendant number 1B and 4, my lord.
What is GA is about?
My lord, your lordship, GA has been filed by the plaintiff, my lord, for withdrawal of the suit, my lord. There is the appointment of a receiver. My lord, receiver is to hand over the papers regarding the question property. He was in charge of the property.
Who is
for
the
la-
receiver?
Receiver is not there at present.
Do you know the name?
Yes, he regularly appears.
At present, there is no GA is pending, my lord. I am appearing for the plaintiff, my lord.
You both of you want to withdraw?
No, my lord, I have.
Plaintiff wants to withdraw.
Plaintiff wants to withdraw my partition suit, my lord. I am to file an application, praying for an order so that the receiver may hand over the papers and documents.
Let me call for, so I can do it so moto.
No, my lord, your lordship, on the last occasion granted me the liberty to file an application. My lord, I could not prepare the application. My client was ill, my lord. That's why I am paying 2 weeks time, my lord.
No, already order is there. Mr. Mukherjee is
Yes,
standard
yes.
receiver is to submit statement of accounts.
No statement account will not do. My lord, he was collecting rent. I want the counterpart of the rent receipt because there are so many tenants. Where from the to start, who, how much the due, and what was the rate of
In
rent.
terms of order dated 1st May 23, the learned receiver was directed to submit statement of accounts when his remuneration was supposed to be considered. কোন রিপোর্ট আছে?
My lord, he is receiving the monthly remuneration from the collection of the rent. Be that as may, my lord, I may be permitted.
The learned receiver is directed to submit the report
Yes.
containing statement of accounts,
And also all the papers.
status of immovable properties,
Yes,
number of tenants residing,
yes. And the rate of rent.
payable in respect of
Hmm.
each of the tenants,
Yes,
outstanding amount of rent, if any,
yes, my lord.
whether
Municipal
share of,
tax.
yes, whether share of municipal tax
Hmm.
shares of are paid or not,
Yes,
or recovered or collected from the occupiers, the quantum of municipal tax outstanding, if any,
yes. My lord, and whatever steps have been taken for realization of the area rent.
steps taken for recovery of area of rents,
Yes,
steps taken for
non-payment of the rent.
removal of squatters or trespassers, if any,
Yes, my lord.
trespassers or squatters,
Hmm.
if any, trespassers or stroke the unauthorized document.
Yes, my lord. This is
And
sufficient.
all other necessary and incidental
Relating to.
facts related to the administration of the estate.
Yes,
The report shall be accompanied by copies of counterpart of the rent receipts,
yes, my lord.
of the rent receipts issued.
Yes,
The report shall be submitted on or before the returnable date. Let the matter appear in the list on 29th August. Copy of this order shall be communicated by the learned registrar original site to the learned receiver for compliance.
yes. My lord, this is sufficient, madam.
My lord, the matter will appear in the list on 9th.
Item 32.
32. None appears. On last occasion, plaintiff sought for accommodation and the same was given on payment of cost of rupees 10,000. Today also, today plaintiff defaulted to appear. Let the matter be dismissed for default, as it appears that plaintiff is not interested to proceed with. Next.
Item 33.
Lordship, for the respondent, the counsel in the matter is indisposed, Lordship. I'm praying for not today.
Where is the last order? None appears for the plaintiff. Learned counsel for the defendant, 6 for accommodation. Accordingly, full stop the accordingly. The matter is adjourned to 26 July.
Lord, in an extreme emergency, Lord, I am mentioning matter item 31, Lord. Your lordship passed an order. Lord, I am the receiver and commissioner of partition.
Come on the next date.
My lord, I will not be here. Your lordship posted this matter on 25th of August. Lord, I will be available in October only. I will not be here. Lord.
File the report.
My lord, I will, day after tomorrow, I will be.
Mention it. Tomorrow, mention it tomorrow morning. Come tomorrow morning, mention it. I will be enlisted. It will be enlisted. Next.
Your lordship, may I mention item number 17, your lordship, which is probably the second 17, your lordship.
Yes.
Your lordship kindly adjourns it to any other day. Your lordship.
This is that matter, your lordship. Mr. Bose, your lordship,
Yes,
has
yes,
completed
yes.
his submission. Mr. Ghosh, your lordship, was
Proceeding with the arguments, your lordship, Mr. Ghosh is in some difficulty, your lordship.
When do you like to have it?
Next week, Thursday. It's 27th, your lordship, if it comes so commences.
You are defendant.
I'm the plaintiff, your lordship.
On prayer of the learned counsel for the plaintiff. Argument is adjourned to 26th July.
Item number 16.
I'm sorry.
Appearing for the plaintiff.
Appear for the plaintiff in this matter. I'm led by Mr. Dhruva Ghosh, who has already made his arguments and he was due to file his notes for arguments. Only one thing, my lord, we need some more time to consider certain points and formulate the final notes for arguments. I'm praying for a week's time to file the notes for arguments.
Who is for the defendant?
Lordship, I'm appearing
They
for
were
the
not
defendant.
appearing.
Lordship, there's a change in the brief. So AOR has been changed. So kindly may allow us to file our wakalatnama for the same. And also we pray to file our recalling application as we have gone.
I'm giving you leave to file wakalatnama right now. Learned counsel for the plaintiff.
Only 2 weeks, my lord, if you kindly grants 2 weeks.
Craves leave. Praise for accommodation. Praise, not craves leave. Praise for accommodation. Learned counsel for the defendant. Comma, on the other hand, craves leave to file wakalatnama. Leave is granted to the counsel for the defendant. Let the matter appear in the list on 4th August.
Grateful man. Grateful man.
Witness action, item number 18.
Well, this matter, Mr. Jhunjhunwala was getting examined in chief. I'm just told that, my lord, there has been a bereavement in his family, so he is unable to come to court.
Adjourn to 4th August. I'm keeping it also 4th August.
Same day, my lord.
4th August.
And I'm led by Mr. Dhruva Ghosh in this matter.
19.
Item 19.
Plaintiff, who is the plaintiff?
And I'm for the,
Mr. Ghosh, you are here for plaintiff.
I'm for the plaintiff, Lordship.
Could you examine him?
I'll cross-examine the witness. Plaintiff.
Yes, please come. I have fixed 2 arguments. None of them are heard.
Praveen K. Popat. Pravin. Popat.
Mr. Ghosh, by the way, just one query, not related to this suit. Is there any rule in original site where undefended suit, no evidence is needed?
Order 8, Rule 5, Sub Rule 2, CPC. If
Yes.
the court requires, court can
It is
ask.
not a question of requiring. If you have any case, you have to prove it.
There is one or two judgments, so far as I recall, of Justice Ojanatri, where he passed the decree, since nobody appeared, it's undefended. That is,
Some evidence is needed.
yes, according to me, yes.
Unless, how can you say it is proved? Proof depends not on pleading.
Materials on record on the basis of which court will come to the conclusion.
Oral evidence.
Oral or
And
document.
not documentary. At least you give oral evidence.
As a matter of course, I don't think it should be done at all because Order 8, Rule 5 says so of CPC.
Someone makes submission in this court. Need not
The
needed.
CPC, Daga, since query has come from your lordship, Sub-Rule 2. Where the
Order 8.
defendant has not filed a pleading, it shall be lawful for the court to pronounce the judgment on the basis of the facts contained in the plain, except as against a person under disability, but the court may in its discretion require any such fact to be proved.
That is the Order 8.
Rule 5, Sub-Rule 2.
But no such provision is there in original side rule.
I don't recall. Because this was used to be followed in our younger days. But I think it is court in its wisdom should direct the plaintiff
So
to.
far as this is concerned, this is a procedural law.
Yeah.
Substantive law is evidence. How would you prove it?
Of course.
This cannot prove a thing. A thing
Pleading by itself is not proof.
is not a proof. Even if you say it is supported by affidavit, affidavit is not evidence. And pleading can stand if it is admitted only.
Yes, that is a judgment upon
Statement
admission.
is filed. Otherwise, it's by itself, pleading is not a proof. Thank you. Because some of the junior friends should be cautious while making submission before the court.
That I don't know. There was a rule to apology. Let's check up.
There cannot be any rule like that.
Because the common sense logic is against it.
Yes.
On the a fact is proved under Section 3 of the Evidence Act when either the court believes it to be correct, true, on the basis of the materials before it,
Absolutely.
or court will think that a prudent man will think that in that way.
Proved, not proved, disproved.
Yes.
So for
Proof is the belief of the court on the basis of the material only.
on the other hand, without having any material, there can be presumption. Where on the basis of presumption, court can come to a conclusion. But when the facts mere plain, I think this should not be done.
For example, if there is something on the basis of Banker's Book Evidence Act, because statute says that is to be sacrosanct unless it is proved otherwise, because that has to be gone into the records.
Presumption, just as like 113B. 113, that those presumptions are different. But that may not be sacrosanct and that may not be a gospel truth. You need not go into the evidence. That goes against the basic rule of evidence.
I think I should point out one thing. On the last occasion, I disclosed certain documents.
That cross-examination part.
Cross-examination.
Yes, that can be done.
So I proceed on the basis.
You produce the document because those order 8 rule 10, that is not applicable when the documents are for the first time produced in cross examination or refreshing memory.
I'm grateful.
Otherwise, you have to take leave if you are a
I am grateful.
But where is that person to oppose?
She is coming, Lordship.
No, let me proceed on the basis of all the documents on record and confrontation or refreshing the memory. These two are the exceptions.
That day, I had so many witnesses waiting. Even I could not finish all the witnesses. So I was in little hurry. Yes, she has came
No, I'm sorry, Lord, I was stuck in 6.
to oppose.
Yes, Milord. Milord, not for any other reason, Milord. It's just that, Milord, we must uphold what the law is.
When I shall place any document, you may get the chance to oppose. If I rely on the documents already disclosed, you can't oppose.
No, if my learned friend relies on.
Suppose a new document is produced.
Yes.
That is your objection, point of objection.
Yes. Milord, for simply, Milord, I first need to understand, is my learned friend, Milord, producing these documents to confront my witness, or Milord, is this additional documents he wishes to rely on as additional evidence?
What he is doing?
Because the test will be different, Milord, for 2. So I'll Milord, formulate my submissions accordingly. And on the last occasion, Milord, my learned friend, senior friend, Milord, submitted that, Milord, he will confront with these documents. That is what he has said.
No, there are two things.
New documents can be produced. You show him, show her. New documents can be produced at the time of cross-examination or refreshing memory. He is producing this document in course of cross-examination.
Correct. So today he is relying on order 8, rule 1A, sub rule 4, I believe. Read with order 13, rule 1, sub rule 3. Because, Milord, both these provisions, subject to correction, Milord, provides for producing these documents at the time of cross-examination to the witness, so far as the defendant is concerned. So far as the plaintiff is concerned also, Milord, order 7, rule 114, Milord, rule 14, sub rule 4 is there, where, Milord, plaintiff can do the same. Now, Milord, what I wanted to say on the last occasion is that additional, so my learned friend wants to only for the purpose of cross-examination, Milord, show this document, which, Milord, must be seen in light of the evidence at, Milord. Today, then, Milord, the procedural part, where, Milord, where he is liable to.
Could you produce anything new today?
Everything is new. He's saying.
May I humbly submit this? I was not supposed to disclose even what I'll go to show.
Yes, for cross-examination.
But right. But I have shown certain documents. If my learned friend finds that I am not in accordance with the law, Evidence Act or
on objection, it will go on objection. At the time of argument, you argue that suppose a document is not admissible in evidence. That document is admitted.
Yes.
That point can always be raised in the course of argument, even in the trial.
Yes.
Even in appeal.
I appreciate. But additionally, I also want to say, I don't want to stand in the way. My suit, Milord, I don't want to delay it. I want him to be cross-examined. Additionally, I want to say, Milord, that when my learned friend wants to produce a new document, which he has not done earlier, and today, if he wants to produce it as additional document, leave is required. He is saying, no, I don't want leave. I want
leave is not required. In course of cross-examination, if it is
cross-examination not required, but otherwise leave is required.
He is not relying on that. He is producing in course of cross-examination.
So you produce in cross-examination.
I am taking it on objection.
Yes,
you argue at the time of
confronting. So for confronting my
witness, that's he is doing.
Section 145, Milord, if he is
let this thing be done.
Order 8, rule 1A, sub rule 4. Nothing in this rule shall apply to documents A, produced for cross-examination of the plaintiff's witnesses, or B, handed over to a witness merely to refresh the memory.
You take it.
Milord, so I am saying that yes, for cross-examination also.
That's all.
But today, Milord, in cross-examination, Milord, kindly see section 136 to 145 onwards. In cross-examination, when he is producing a new document, one is a surprise element, Milord. He is saying that I have already given, so there is no surprise.
1A, just go through it.
145.
Well, not 145. This is the
Rule
if
4A and B down.
I have shown that. So that the judgments are there which cross-examination 4 has been read with section 145. That very well you cross-examination, you produce a new document, but you have to ensure it's not a third-party document because it is always to, my lord, dispel what the plaintiff has said in his examination in chief, to contradict that or to, my lord, dispel and come out and take the truth
how
out.
can you say it is not for that?
Not for that, my lord. I have judgments, my lord. I'll place. I will opt.
Is this document, why this document is produced?
I may not show to him,
Very well. Let me just
show to him all the documents. I think the objection should be made when a particular document can be maybe objected to.
And only for the purpose of cross-examination
Produce this document. Yes, that's what
and
he is doing.
contradicting what my witness
Yes,
says.
that's he is doing.
Yes, any third party giving me what is this document, who has signed this, my lord, that, my lord, cannot be done. Third party document, my lord, in cross-examination cannot go in evidence through my witness.
Produce it.
Anything he has said to contradict that, you have said that that is a lie. I am showing something. My lord, section 164 criminal
All right, I got your
procedure.
point.
Yes, that's all.
Yes.
Kindly showing the plaint. I think it is inter-party documents. Really. আরে ঠিক আছে দাঁড়াও না বলতে বলুন না
May I take your, I have object to that. No, may I take your note?
প্লেনটা দিয়েছেন kindly look at paragraph 4 of the plaint filed by the plaintiff in the present suit. Shown paragraph 4 of the plaint within brackets. Yes. Kindly look at the writ of summons and the copy of the plaint received along with the writ of summons. Copies of which are marked as DD number 10 at pages 60 to 67 of the Judge's Brief of Document, first volume. Kindly look at particularly to the cause title of the plaint filed in ejectment suit number 419 of 1992. Yes. This is the plaint filed in the ejectment suit number 419 of 1992, which has been pleaded in paragraph 4 of the plaint filed in the present suit. Am I correct?
Yes, you are correct.
This suit being ejectment suit number 419 of 1992 was filed by the plaintiff hearing against the defendant hearing in the Learned City Civil Court at Calcutta. Am I correct?
Yes.
Kindly come to the relief claims in the said suit which is at page 66.
Is it exhibit?
No, I shall tender it as exhibit. Which is at internal page 6 of the plan.
Yes.
This ejectment suit was filed by the plaintiff hearing against the defendant hearing, claiming inter alia a decree for recovery of khas possession of the suit premises, which is the same as the suit premises in the present suit. Am I correct?
The same premises.
The plaint in ejectment suit number 419 of 1992 was verified by Jayanti Lal G. Patel. Am I correct?
Yes.
Do you know Jayanti Lal G. Patel?
I know him.
Who is he?
He was the honorary secretary at that point of time.
He was the
Honorary secretary of the plaintiff at that point of time.
Kindly go through the plaint filed in ejectment suit number 419 of 1992, which was served on the defendant herein, along with the writ of summons, and tell my lord where this is the copy of the plaint filed by the plaintiff herein in ejectment suit number 419 of 1992.
The Xerox actually. This is Xerox.
This was the service copy. Writ of summons is there. First page dekhiye din ekটু na.
Yes, this is the copy of the suit.
May go.
yes.
The writ of summons, along with the copy of the plaint,
This is original writ of summons.
originally, which was copy of the plaint filed in ejectment suit number 419 of 1992. Please write the original writ of summons. Right?
Exhibit 1.
Huh?
Exhibit 1.
It should be exhibit 1. Along with the copy of the plaint filed in ejectment suit number 419 of 1992
Exhibit 1 in bracket collectively.
is tendered in evidence and marked exhibit 1 collectively. I do not quote it up. Kindly look at paragraph 6 at page 5 of the plaint filed in ejectment suit number 419 of 1992. According to the plaintiff, therein, that is the plaintiff herein also, the defendant was liable to pay rents at the rate of 12,781.26 paise per month from August 1989. Am I correct?
Yes.
Kindly come to paragraph 5 of the plaint filed in the present suit, that is CS number 317 of 2003.
Yes.
So, according to the pleading of the plaintiff in the present suit, the defendant herein has paid rent to the plaintiff society up to the month of August 2003. Is it correct?
Yes.
Kindly consider paragraph 6 of the plaint filed in ejectment suit number 419 of 1992 and the last sentence of paragraph 5 of the present suit. Is it the case of the plaintiff as on the date of filing of the present suit that the defendant has paid rents to the plaintiff at the rate of rupees 12,781.26 paise per month from August 1989 to August 2003.
That is not correct.
Do you want to depose before my lord that the defendant has not paid rent to the plaintiff society for the period from August 1989 to August 2003?
As far as I remember, the old outstanding rents were deposited with the learned court. But
Which learned, sorry, sir. Please continue. Learned court, then.
before the before the before the trial court in the city civil court.
Anything more to add?
And thereafter rents were received directly also from the defendant. But what rents were paid in court and what rents were received directly by the plaintiff, I am unable to recall clearly. But up to August 2003, nothing is outstanding.
And that is why the plaintiff has not claimed any amount against the defendant in the present suit on account of arrears of rent. Am I correct?
The present suit is not on account of outstanding rents.
Please repeat the question. Please answer the question.
Yes, there are no areas of rent at that time.
Kindly look at Exhibit B in the present suit, being the original agreement dated 29th October 1973, which is DD number 1 at pages 1 and 2 of the judge's brief of document 1, number 1. Shown, Exhibit B. Kindly look at clauses 1 and 2. Sorry, this is the letter given by the defendant hearing to the honorary secretary of the plaintiff hearing. Am I correct?
No, this letter was issued by the predecessor in interest of the defendant.
And this letter dated 29th October 1973
Yes.
indicates the commencement of the tenancy granted by the plaintiff in favor of the predecessor in interest of the defendant.
Yes, this indicates that the tenancy will start from the 16th day of October 1973.
Can you tell my lord, after going through clauses 1 and 2 of Exhibit B, that is the letter dated 29th October 1973, what was the total monthly rent at the rate of rupees 1.50 paise per square feet in respect of 7,350 square feet, excluding owners and occupiers shares of corporation taxes or any other corporation tax, excluding, I said.
The figure of the monthly rent is not exactly given here. It says 1 rupee 50 paisa per square foot was 7,350 square feet, and 3 months rent is mentioned at 33,075, which is equivalent to 11,025 rupees per month.
So, the rent part, so the monthly rent, excluding the corporation tax, etc., was 11,025,
Correct.
rupees 11,025 in respect of the suit property since the commencement of the tenancy on and from 16th October 1973.
That
Am I
is correct. That is right.
Kindly look at clause 4 of Exhibit B, being the letter dated 29th October 1973. Did the defendant pay to the plaintiff the sum of rupees 33075? That is the amount equivalent to 3 months rent at the rate of rupees 11025.
The defendant's predecessor in interest paid to the plaintiff the amount of 33,075.
Can you recall whether the plaintiff acknowledged in writing the amount received by the plaintiff from the defendant to the extent of rupees 33075 to the defendant or his predecessor in interest? To the defendant or his predecessor in interest? Repeat one question.
We must have given a receipt when we received the amount.
Can you recall the date of such receipt?
No, the date I cannot recall.
If I tell you that by the letter dated 30th October 1973, addressed to Bajbaj Amalgamated Mills Limited, the predecessor in interest of the present defendant, the plaintiff has acknowledged receipt of the letter dated 29th October 1973 of the predecessor in interest of the defendant, along with the tenancy agreement of the suit premises and a check for rupees 33075 in terms of clause number 4 of the said agreement. Please repeat the question.
Addressed to Bajbaj Amalgamated predecessor in interest of the present defendant, the plaintiff has acknowledged receipt of the letter dated 29th October 1973 of the predecessor in interest of the defendant, along with the tenancy agreement of the suit premises and an amount of rupees 33075 in terms of clause number 4 of the said.
Would you be able, would you contradict my statement?
Well, I will not contradict it, but I will not confirm it also.
Do you want to depose before my lord that you do not recollect the date of the letter, or that whether any letter dated 30th October 1973 was issued by the plaintiff to the predecessor in interest of the defendant?
Question clear?
Or that whether any letter dated 30th October 1973 was issued by the plaintiff predecessor in interest of the defendant.
A letter was issued, but the exact date I cannot recollect.
May I to refresh the memory? Show him that. I am showing you The original letter dated thirtieth October 1973, written by the plaintiff herein to Messrs. Bajbaj Amalgamated Mills Limited, the predecessor in interest of the defendant, is it the letter acknowledging the receipt of the tenancy agreement and the check for rupees 33075 by the plaintiff?
This letter is admitted. Admitted.
If it is for refreshing the memory, he will refresh the memory looking at it and reply orally. So
Yes.
how can it go? How can it be exhibited? Let his reply come. It is only to refresh his memory.
Yeah.
So let him say what is there without it being exhibited.
No, it is admitted, he said. He said, last answer. Please repeat the answer.
This letter is admitted.
See. 2. It will be 2.
2, exhibit 2. The original letter dated 30th October 1973, a copy whereof has been disclosed by the letter dated 10 July 2023 by the advocate on record of the
You disclose it earlier.
event. I have disclosed it before.
Then there is no
I didn't want to, my lord, take it by surprise because this is their letter. Is tendered in evidence and marked as exhibit 2. To repeat,
Any signature is there?
Huh?
Any signature is there?
Yes.
Whose signature is there on the letter?
May I put
The signature is of Jayantilal Patel, the former honorary secretary of the society.
Can you identify the signature?
I can, my lord.
Signature marked as 2 by 1.
Jayantilal Patel.
2 by 1. Signature 2 by 1.
Secretary of the society at that point of time.
Jayanti. Jayanti. Kindly look at exhibit 2. লিখে রাখো ঠিক করে পরে কাইন্ডলি give me আজকে কত exhibit 2 being the letter dated 30th October 1973 of the plaintiff, particularly the first 2 lines thereof. The plaintiff has acknowledged receipt of the letter dated 29th October 1973 of the defendant, along with the tenancy agreement and the check for rupees 33075. Do you have the original letter dated 29th October 1973? Sorry, do you have, have you disclosed the original letter dated 29th October 1973 of the predecessor in interest of the defendant as mentioned in Exhibit 2?
Yes, I think so. We have disclosed.
Okay. Okay.
Yes, I think I have disclosed.
Judge's brief of document, shown the judge's brief of document, particularly the index thereof. Kindly point out to my lord the serial number in the judge's brief of document which corresponds to the letter dated 29th October 1973 of the predecessor in interest of the defendant to the plaintiff. From the predecessor in interest of the defendant to the plaintiff.
This shows that the defendant has produced the original and the plaintiff has not done so. It is marked as
if you find
DD number 1.
Huh?
DD number 1.
May just please read that Exhibit 2. First line.
Yes, this letter
Dated 29th
October 1973.
along with tenancy agreement. That means this agreement is a separate, this letter is a separate letter.
Yes.
Have you
It
discussed
says,
that?
it acknowledges that a letter was received and an agreement was received and the amount was received by check.
Are you in a position to indicate before my lord that whether the plaintiff has disclosed the letter dated 29th October 1973 by which the tenancy agreement dated 29th October 1973 and the check for rupees 33075 was forwarded by the predecessor in interest of the defendant to the plaintiff.
No, it was not disclosed.
I am showing you the office copy of a letter dated 29th October 1973 written by the predecessor in interest of the defendant to the plaintiff to refresh your memory as to whether this is the forwarding letter dated 29th October 1973 by which the tenancy agreement and the check for rupees 33075 were forwarded by the predecessor in interest of the defendant to the plaintiff. Shown the office copy of the letter, shown the office copy of the letter dated 29th October 1973, which was disclosed which has been disclosed by the defendant by its advocate letter dated 10 July 2023. This is a forwarding letter.
I don't exactly recollect this.
By the expression quote unquote this, what do you mean?
We have acknowledged the receipt of a letter. Whether this one is exactly the same, that I cannot say.
Mark for identification.
X for identification. Or if anything is marked as X, check it. Any other document is it marked as X?
I don't think.
In that case, it will be X1 or X2 like that.
Kindly keep it as X1. It will be, if there is some other document, that serial may be.
It should be X if no other document is there.
No, I don't think exhibit X is not there.
Then it will be the first document. X for identification.
Plaintiff's exhibit list देखो नहीं तो. Please
Then it will be X.
mark for it.
How long would you take?
It will take some time.
So I will fix it another date.
Yes.
Try to finish on that date. He is PW1.
PW.
PW1's examination in chief is resumed today. He is you're cross-examining him. Sorry, cross-examination of PW1 is resumed today. Full stop. PW1 is cross-examined in part. Full stop. One document is produced by Mr. Ghosh, the learned counsel for the defendant. The learned counsel for the plaintiff objected to production of that document since it is an undisclosed one and not hitherto been disclosed. This objection is overruled in view of express provision of Order 8 Rule 1A of the CPC. And especially this document is used for contradicting the witness.
Here refreshing the memory.
The second one you have already disclosed. The second one you have disclosed.
Both disclosed.
Both are disclosed document.
Both.
Then what is the objection?
Because I have disclosed new document. For the sake of benefit of everybody, I did not put it out from my pocket to refresh.
Disclosed document.
By the letter date, I mentioned that. By the letter dated of 10 July 2023 of my advocate.
The documents were marked as B, Exhibit B and Exhibit C.
No, Exhibit B.
Exhibit B, full stop. The document is marked as Exhibit B.
And the second one marked for it.
Another document is also produced, which is marked as Exhibit C.
No,
one is C. C and C.
No, one is B.
First A.
Sorry, I'm sorry. First one is 1.
Sorry, one Exhibit 2. Second one, first is Exhibit 1. Second is 2. And the signature identified is marked as Exhibit 2 by 1. The third document is marked as X for identification. Further cross-examination is deferred to 3rd August.
Third August means after 2. After 2. Or some appellate matters are taken up maybe on 4th or
4th August?
any other time.
आगे कोई date नहीं?
Twenty.
25th July.
26 is a Wednesday. There is no appellate side day. That is why I prefer that subject
You
to.
want 26,
That's a Wednesday, no appellate side.
26.
I'm grateful.
Item number
Yes.
20,
I appear for the defendant since it is a change brief. I sought for certain documents.
Is for the plaintiff.
Your Lordship, I appear for the plaintiff in this matter, Your Lordship. Your Lordship, the witness was cross-examining in part, Your Lordship, and my witness is only him. So my learned
Since
friend,
the change brief, I sought for certain documents from the department which is yet to be supplied. If you, Your Lordship, can you copy the link?
Learned counsel for the defendant submits that he has recently got a change brief for which he is not yet prepared for further cross-examination. Your witness is being cross-examined.
yes, Your Lordship.
Accordingly, the matter is adjourned to
But should kindly fix the date any day subject on subsequent to 10th of August, Lordship, because
18th August.
I'm grateful.
Orders, Your Lordship.
Department may be directed to act to furnish the documents in terms of my latest.
File it according to the rules, it will be done.
Lordship, I'm grateful.
item 21,
Yeah, appearing for the plaintiff, my witness was in the box. I was examining my witness. The chief is going on, Lordship.
Who is with the other
The
side?
defendant was present on the last occasion. They
Where
had
is your
sought,
witness?
my witness is here.
Produce it.
Lordship recollects that all the documents, the only copy that I had, the examination had started. All the documents have been lost and the GD and that has been provided on the last occasion, and Lord, they had sought time to seek further instructions and we will.
Would you examine today or not?
Yes, yes, I am ready.
SHAR.
The judges brief of documents to work with. Judges brief of documents. Mr. Thakur, kindly look at the document from pages 1 to 82 of the judges brief of documents and kindly tell my lord what is this document.
Where are the originals?
There is no original because on the last occasion, Lord, you will see the deposition. I have already said entire set of documents have been lost. The original GD have been produced before this honorable court. This was lost because of the changed brief. The erstwhile advance record is no more and
a complete set of tender documents.
Where are the originals?
অরিজিনাল তো ডিপার্টমেন্টের কাছে আছে, আমরা তো টেন্ডার ড্রপ করার সময় অরিজিনাল ডিপার্টমেন্টের কাছে থাকে। এবার হ্যাঁ, আমরা সার্টিফাইড কপি পাই কিন্তু সেটাও স্যার মিসিং হয়ে গেছে ডিপার্টমেন্টের কাছে। ডিপার্টমেন্ট ডিপেন্ডেন্ট
Which department?
পিডব্লিউ এনএইচ ডিভিশন
PWD state of
For this document.
Yes,
NH, National Highway Circle.
She will provide in the order. I have no difficulty. She will can provide in the order. They will have. They will produce the original.
To the court, the original is lying with Public Works Department.
No,
my lord, National Highway.
National Highway,
Circle 3.
Circle number 3.
circle number 3. Is it a copy?
Copy.
Authorized copy, authenticated copy by them?
Certified copy in the Xerox.
Is it the original photocopy of the certified copy?
Yes.
It is the photocopy of the certified copy. You have to produce the certified copy. If you have
Certified copy, that is what I am saying. The certified copy we were given, that is lost. These were the entire set of documents which was lost from the erstwhile Advent Records office.
we have lost the certified copy from the erstwhile Advocate on Records Department. Erstwhile Advocate on Records Office. So you call for the original.
Yes.
Marked as X for identification.
Mr. Thakur, I'll continue. Lord.
Let the original come, compare it with,
Yes.
then it will be marked.
Very well. Because entire, these are all intercommunications between the parties.
Do one thing, which documents will be are there? You prepare these things will be done easier.
Lordship will have a look at the index once. There is an index of the judge's brief of documents. All these letters are intercommunicated. Either I write to them or they write to me. So there is no question of anyone denying any of the documents. These are letters in a works contract. Judge's brief of documents take with these. Lordship will have a look at the index once.
All these are copies.
All these are copies. If it is written by me, the original will be with them.
But you have not produced the original here.
No, because before
With
you
their letter, you have not produced the original of their letter also.
no, because all their letter I have lost and our letter original will be with them.
You do one thing.
Yes.
You sort out which documents are there in their custody.
Yes.
Call for them. If it is not produced, we will mark it.
Very well. And that will be easier, much easier. Yes, I need not then go through that effort of every document I producing. Yes, I'll do that. Lordship.
Adjourn.
Yes, yes. Lordship will kindly also provide that in their order once if
PW 1 is partly examined in chief. The learned counsel submitted that most of the documents are lost from the office of the erstwhile advocate. So leave is sought for to call for the original documents from this custody of the state. So long as these documents custody of the state. Leave is granted. Further examination in chief is adjourned to 10th August. Do one thing here for the state.
Yes.
So do one thing, check out which documents you are admitting, because originals could not be produced.
I'm grateful. Yes.
Those
yes.
will be admitted and marked.
Yes.
Things will be easier.
Yes, otherwise.
The brief again, Milord, has just come because of the change in panel. I wasn't sure if admission denial is there. And it's very difficult to get instructions. So it's good that your lordship, Milord, I'm very grateful, is passing an order.
The learned counsel for the defendant also seeks liberty, since she has recently received the brief, to check the documents which are to be admitted and denied. Stop. The exercise is to be done within the returnable date.
Yes, and Milord, issues I believe, have not been framed.
Definitely issues must have been framed. Otherwise, why it is in?
It is a 2004 suit, Lordship. I could not find documents, anything. Whatever I could get is from the records of this court. I got certified copies. I could not find anything. Hmm.
Issues are here. 22/8/2006.
Lordship, may we take copies because
Yes, I don't.
I also don't have anything.
The learned counsel
In fact, what happened was the entire brief is from certified copy
for
of this
the
document.
plaintiff also learned counsels of both the parties seeks leave to obtain copies of the issues. Full stop. Leave is granted to obtain them in terms of original side rules.
In fact, Lordship, there is an affidavit of documents.
Nothing. Check it and put it down.
Yes, yes. Lordship, in fact, there is an affidavit of document filed on behalf of the state also. I could find that. So these documents, they are also admitting.
So that this streamline
Yes.
things, sit together, find out which documents are to be admitted, which are to be denied. Those, because you have lost the originals.
Yes, I have lost the original.
And secondary.
So on admission, those documents will be marked.
Yes. Because these are all inter-party documents, what will the
Probative value ultimately in the.
the contents will be with regard to the arguments only.
Down to
nothing
that
more.
point.
Yes.
I am learning suit. It's very interesting. I want to do a few more. And Millard, I am also very glad, Millard, that when I make submissions, your lordship does not throw me out at the initial.
Why?
Yes, your lordship hears me. And then Millard, it feels good that Millard, after a point when I make some sense to your lordship allows that. So.
All right.
Highly privileged.